Thank you. Please be seated. Court is now in session. Calling case number 251-403-576, State of Utah versus Tyler James Robinson. Counsel, please enter your appearances.
State.
Good morning.
Good morning, Your Honor. Kathy Nestor, Michael Burt, Richard Novak, and Stacy Visser for Mr. Robinson, who is present.
Good morning. Good morning to Mr. Robinson. All right. Before addressing today's business, the court takes up a couple of preliminary matters. First, with respect to courtroom protocol to maintain security and decorum, any individual who exits the courtroom during proceedings will not be permitted to re-enter until recess. All counsel are expected to take reasonable measures to safeguard confidential communication. Such measures may include the use of screen protections on electronic devices and care to avoid the inadvertent capture of privileged or private discussions by recording equipment or by those present in the courtroom. In addition, the microphones at counsel table are turned off as a further precaution. And when making argument, if that occurs, I ask you to approach the lectern when you do so. Second, the court will address the camera operator and still photographer. And would those individuals please come forward to the lectern. Thank you. If you could state your full name, both of you. Good morning. So the purpose is to ensure clarity regarding the expectations governing today's proceedings. And could you, have you reviewed the court's standing decorum order dated February 24th, 2026?
Yes.
All right. Do you understand the requirements set forth in that order as they apply to your activities today?
Yes.
Do you require any additional time to review the order or to adjust equipment to ensure compliance? And do you anticipate any difficulty complying with the order? All right, I appreciate your cooperation. Thank you. Turning next to defense motion to stay pending interlocutory review, and the court will issue its ruling on this matter. Before the court is defendant's motion to stay pending interlocutory review. Defendant seeks to stay all further proceedings in this capital case, specifically the preliminary hearing scheduled for the week of July 6, 2026, pending the Utah Supreme Court's disposition of his petition for permission to appeal from an interlocutory order. The state filed objection to the motion, and defendant subsequently filed a reply. Having considered the parties' briefings, the factual record, and the relevant authorities, the court issues the following ruling and order. Defendant is charged with the aggravated murder of Charlie Kirk, a capital felony offense. The media interest in this case is extraordinary within the state of Utah. Due to this intense public interest, defendant previously filed a motion to exclude still photographers, TV cameras, and microphones from the courtroom, seeking a categorical ban on electronic media coverage during all proceedings. On May 8, 2026, this court issued its camera ruling, denying defendant's request for a blanket ban and concluding that under Utah Rule of Judicial Administration 4-401.01, requests for electronic media coverage must be evaluated on a proceeding-by-proceeding basis rather than through a categorical prohibition. The court also established procedures designed to provide advance notice of media requests and an opportunity for the parties to be heard before any such request is decided. Subsequently, on May 29, 2026, defendant filed a petition for permission to appeal from an interlocutory order with the Utah Supreme Court, challenging the camera ruling on state and federal constitutional grounds. On June 6, 2026, the Supreme Court issued an order requesting that the state and various media organizations file responses to defendant's petition within 14 days. Additionally, on June 1, 2026, this court denied defendant's motion to close portions of the upcoming preliminary hearing and seal exhibits, concluding that defendant had not demonstrated a realistic likelihood of prejudice sufficient to justify closure, particularly where much of the information at issue was already publicly available. The parties dispute the precise legal standard governing a motion to stay pending interlocutory review. Defendant argues that the granting of the stay lies within the inherent and discretionary powers of the court, varying according to the requirements of each individual case. In addition, defense argues Rule 8 of the Utah Rules of Appellate Procedure, which requires him to request a stay in the trial court before seeking a stay from the Utah Supreme Court. Conversely, the state argues that under Rule 8C2 of the Utah Rule of Appellate Procedure, a movement must demonstrate A, a likelihood of prevailing on the appeal, B, a likelihood of irreparable harm to the movement outweighing the harm to any other party, and C, that the stay is not adverse to the public interest. Defendant contends the factors contained in Rule 8C govern the waiver of a bond or security requirement and do not establish the substantive standard for granting a stay itself. The court concludes that regardless of whether the motion is analyzed under the discretionary authority recognized in Lewis or under the factors identified in Rule 8C, the result is the same because defendant has not established either a sufficient concrete threat of irreparable harm or that the balance of equities favor a stay. Defendant argues that proceeding with the July preliminary hearing while his petition remains pending will cause irreparable harm to his constitutional rights to a fair and impartial jury. Specifically, defendant relies upon the expert opinion of Dr. Christine Ruva, who opines that electronic media coverage of the preliminary hearing may expose prospective jurors to inadmissible hearsay evidence and create unconscious bias. Defendant further relies on Shepard, James, and Hollingsworth, arguing that once the proceeding is publicly broadcast, any resulting prejudice cannot be undone. The court takes defendant's concerns seriously. The potential impact of extensive media coverage in a capital case is neither hypothetical nor trivial. The court further recognizes, unlike many forms of pretrial prejudice, widespread dissemination of information through modern and electronic media may be difficult or impossible to fully reverse once it occurs. The question presently before the court, however, is whether the record establishes a sufficient concrete and imminent risk of prejudice to justify staying all proceedings while interlocutory review remains pending. The court concludes that the asserted threat of prejudice has not yet been shown on the present record to be sufficiently concrete to justify the extraordinary relief requested. The court does not minimize defendant's concerns regarding publicity in a case of this magnitude. Indeed, the court has previously recognized that media attention surrounding these proceedings is extraordinary, and that dissemination of preliminary hearing evidence presents challenges not ordinarily encountered in most criminal cases. Nevertheless, extensive publicity does not, standing alone, establish that an impartial jury cannot ultimately be selected. Courts have long addressed highly publicized prosecutions through established procedural safeguards, including expanded jury pools, detailed jury questionnaires, individualized voir dire, venue-related remedies where appropriate, and careful judicial supervision of the jury selection process. As is United States Supreme Court observed in Nebraska Press Association versus Stewart, pretrial publicity does not inevitably lead to an unfair trial, and predictions regarding its ultimate impact are often uncertain. Likewise, prominence does not necessarily produce prejudice, and jury impartiality does not require ignorance. In its June 1st, 2026 order denying closure, this court concluded that defendant had not demonstrated a realistic likelihood of prejudice sufficient to justify closure of the portions of the preliminary hearing. Should concerns regarding prejudice arise as the case progresses, this court retains broad authority to employ traditional safeguards to protect defendants' constitutional rights, including expanded voir dire procedures, comprehensive jury questionnaires, individualized voir dire, changes of venue when warranted, and other remedies authorized by law. Moreover, no media organization has yet filed a request for electronic media coverage of the July preliminary hearing, and the court has not been called upon to determine whether such coverage will be permitted. Accordingly, the asserted injury presently depends upon future events that have not yet occurred, including whether any request for electronic media coverage will be filed, and if so, how the court will rule on such a request. At this juncture, the court cannot assess those contingencies with sufficient certainty to conclude that a stay is necessary. The court recognizes defendants' arguments that the alleged injuries arise not merely from the possibility of future media requests, but from the operation of the framework established in the court's May 8, 2026 order, while appellate review remains pending. The court has carefully considered that concern. However, because any request for electronic media coverage remains subject to case-specific review, and because no determination regarding coverage of the preliminary hearing has yet been made, the court concludes that the asserted injury remains contingent rather than immediate. On the present record, the possibility of future electronic media coverage does not establish a sufficient concrete basis for staying all proceedings pending interlocutory review. The court's denial of a stay should not be understood as a determination that the defendant's concerns lack merit. Rather, the court concludes only that the current record does not establish that such concerns have matured into a concrete and immediate threat request requiring present intervention. Given the procedural safeguards available to ensure the selection of impartial jury, defendant has not established irreparable harm warranting a stay at this time. In balancing the equities, the court must also consider harm that a stay would impose upon other interested parties. The state argues that delay may impair the orderly presentation of evidence, increase risk of faded memories, and affect witness availability. The court finds those concerns legitimate and entitled to consideration. Additionally, the victim representative has formally asserted her right to a speedy disposition of this matter. Under the Utah Constitution and Utah Code, victims possess important rights to proceedings free from unreasonable delay, and courts are obligated to consider those interests when exercising discretion in criminal cases. The court acknowledges defendant argument concerning victims' rights and defendants' constitutional protections. However, because the court has concluded that the defendant has not demonstrated a sufficiently concrete threat to those protections on the present record, the court finds that interests favoring the continued progression of the case weigh against imposing a stay. The court continues to adhere to the reasoning set forth in its May 8, 2026 camera ruling and its interpretation of Utah Rule of Judicial Administration 4-401.01. At the same time, the court recognizes that reasonable jurists may disagree regarding the proper application of that rule in a case receiving this degree of public attention. The court further recognizes that the Supreme Court's request for responses indicates that defendant's petition presents substantial issues warranting careful appellate consideration. The court does not regard the Supreme Court's request as a routine procedure event and acknowledges that the issues raised are of sufficient significance to merit serious review. The court expresses no opinion regarding whether the interlocutory review ultimately should be granted. The existence of a substantial legal question, however, remains distinct from the separate question presently before this court, whether the defendant has demonstrated that a stay is presently necessary pending further review. The court remains persuaded that the procedures established in its May 8, 2026 order are consistent with Rule 4-401.01 5.01. Any future requests for electronic media coverage will be evaluated on the specific record then before the court, after affording the parties a full opportunity to be heard pursuant to the procedures previously established. Finally, the court concludes that the public interest presently favors allowing this matter to proceed in the ordinary course. The public possesses a substantial interest in the fair, orderly, and timely administration of criminal justice. The court further recognizes that public confidence in the judicial process depends both upon transparency and upon the preservation of constitutional trial rights. The court remains committed to safeguarding both interests throughout these proceedings, staying the preliminary hearing while the Supreme Court considers whether to grant discretionary interlocutory review would result in additional delay despite the absence of a presently demonstrated need for such relief. The court recognizes the seriousness of defendants' concerns and the significance of the issues presented before the Supreme Court. The court further recognizes that concerns regarding pretrial publicity and electronic media coverage implicate important constitutional values and warrant careful judicial review. Nevertheless, the potential prejudice identified by defendant has not yet matured into a concrete and immediate threat requiring intervention in form of a stay. Established procedural safeguards remain available to protect defendants' right to a fair trial should further circumstances warrant their use. By contrast, a stay would impose an immediate and concrete burden upon continued progression of this case, including the interests of the state, witnesses, and victim representative, as well as the broader public interest in the timely administration of justice. Nothing in this order should be construed as foreclosing defendant from renewing an appropriate request for relief should further developments materially alter the circumstances presently before the court. Should future developments demonstrate a material difference of level of publicity, media exposure, jury contamination risks, or other circumstances affecting defendants' fair trial rights, the court will not hesitate to revisit appropriate protective measures. Likewise, nothing in this order predetermines how the court will rule on any future requests for electronic media coverage of a particular proceeding. Accordingly, the defendant has not established that a stay of the proceedings is presently necessary or appropriate. It is hereby ordered that the defendant's motion to stay pending interlocutory review is respectfully denied. And that concludes the order of the court as it relates to the stay. Mr. Novak.
Thank you, Your Honor. On the same subject matter, and with respect to the timing laid out in the court's May 8th, 2026 order, we have a concern on behalf of Mr. Robinson that for the court to, well, let me just back up. There has been a request for electronic media coverage in every single hearing in this case. So I think it's fair for the court and the parties to anticipate that there will be a timely, under the May 8th ruling, request for electronic media coverage for the preliminary hearing. Mm-hmm. The court set up what I'll call a briefing schedule for how the parties respond to that request for electronic media coverage, but it appears to us that the court wouldn't rule on the request for electronic media, any request to prohibit or limit electronic media coverage until the morning of the preliminary hearing. And I think that creates some problems, at least for Mr. Robinson, because if the court were to disagree with the relief Mr. Robinson seeks, we have no opportunity to seek review of your Honor's order. And the court just laid out its acknowledgement that there are serious constitutional issues which other jurists may disagree with vis-a-vis the court's conclusions. So the request is that the court modify in some way the timing of that litigation so that the parties and the media can have and their counsel can have a ruling sufficiently before the first day of the preliminary hearing so that if some judicial review is going to be sought, it's not happening after the preliminary hearing has already begun.
No, and I appreciate that, Mr. Novak. I note your concerns, and it is for that very reason that the court modified what was the procedure before, which, and please correct me if I'm wrong, I'm kind of going off my memory, but the media was required under the rules to give, was it 1 day notice before the hearing?
It was something like that. So the notice.
Hold on, I want to finish, sorry,
Yeah.
but I appreciate you. And so the court expanded that to allow briefing, where under the current rules, as they're stated now, it wouldn't even allow for briefing. It would create a greater issue that you're proposing, because you wouldn't even be able to file a motion, no response and no reply. The intent of the court was to give the parties sufficient notice or more notice than the rule currently allows, to allow briefing, to allow that to be presented, and for the court to consider that as opposed to making a snap decision the morning of the prelim. So the court's coming in with more information than simply the request for media coverage being filed the day before, and then the parties trying to come up with an argument, and the court trying to make that decision on the day of trial. And so that's the difference, and the court anticipated that concern and wanted to give the parties that ability to articulate their concerns and allow the court sufficient time to consider those arguments and weigh those arguments against the constitutional rights of all parties and render the best decision it can.
So I acknowledge all of that. I agree with all of that. I appreciate all of that. What I'm referring to is Mr. Robinson's, or, depending upon how the court rules, the state or the media's opportunity to seek interlocutory review if, as Your Honor states, it is true that what has to be shown is the harm under facts that relate specifically to the preliminary hearing. Okay, so the court has denied what I'll call a more general blanket request to preclude electronic media coverage. The court has said it's going to take it up on a hearing-by-hearing basis. And the court has also said that reasonable jurists may disagree with the court's substantive conclusions and the court's ruling on our request for a stay. And what I'm suggesting respectfully is we may be in the exact same place, one of the parties may be in the exact same place in the moments before the preliminary hearing, at least presently, is scheduled to begin on July 6th. So my question is, can we get a ruling from the court sufficiently before July 6th so that if some party seeks a stay and interlocutory review, we're not doing that on July 6th or July 7th or July 8th, because by that point in time, it's too late. So we could have a ruling by WebEx, we could have argument and ruling by WebEx. I totally respect that the court has a very busy calendar, and I also understand that the preliminary hearing is starting 2 days after the 4th of July, which this year is a big deal. So what I'm trying to just do is plan ahead and think about whether the schedule that the court set, which we agree makes a significant difference in our ability to litigate before Your Honor the issue, a way to resolve this so that we also have the ability to seek review before it's too late.
No, and
I'm literally talking about the last few days of the week before. That's, I think, what we're talking about.
And I appreciate that. And where I'm coming from is the court cannot issue anticipatory rulings. I can't go off hypotheticals. And I understand what you're saying. I recognize that media requests have been filed, but I can't issue a hypothetical ruling. It has to be squarely before me. And I respect what you're saying, but I imagine that you're probably preparing, well, I'm not going to assume, it's not appropriate, but perhaps you are already preparing those motions in anticipation of such media requests being filed, and in addition to anything else that you may consider, and rightfully so. And so and there's also sufficient time between now, given the ruling that the stay is not being granted, knowing that the preliminary hearing is moving forward, that it appears that there may be sufficient time for the parties to prepare accordingly. Again, the court needs to wait until it's squarely, that media request is been filed. Whether the parties file motions, it's possible that the parties may or may not. I can't anticipate that, but I need to wait until it's actually before me, as opposed to trying to read the tea leaves and guess.
I'm not asking the court for tea leaves, so maybe I've been obtuse. What I'm saying is that the court's order currently provides that it will issue its ruling on any objection to an EMC request the morning of the hearing. And that's the problem. I'm not asking the court to issue a ruling now. I'm not asking the court to assume there will be an EMC request. I can tell the court that if there is an EMC request, we will file an objection to that, which shouldn't be a surprise. And so what I'm just saying is, for the orderly administration of justice, and in light of the possible judicial divergence of opinion that Your Honor has acknowledged, we are asking the court to build into the schedule that it has set for any objections to any EMC request that may be filed, a period of time before the subject hearing at which the parties would receive a ruling. And if I suggested in my statements that we are actually asking the court to assume that there's an EMC request and that we would oppose it and that we're asking for a ruling now, we're not. We think there should be a request and there should be briefing. We're just asking that the court build into the schedule a ruling moment that allows us, if necessary, or some other party, if necessary, to seek review.
Thank you, Mr. Novak. And the other kind of X factor is how quickly the parties respond. If a motion is filed, and let's say an EMC comes out on day one, and a motion is filed on day two, and then the state files on day three, there may be more time. And so one of the variables is how quickly the parties respond, which the court doesn't control. And so that's a factor that may allow the court additional time to accomplish that. And this court has tried to be very diligent in in expediting addressing motions and not letting them sit too long, because I know it's important to defense and to the prosecution and to all parties. And so the court is cognizant of that and will respect that and issue its rulings or its analysis as quickly as possible to afford you that ability.
So the court did set deadlines for briefing, and what I will do when there's an appropriate break in today's proceedings is we'll speak with counsel for the state about whether we can agree to modify that briefing schedule that the court set so that the EMC request and the parties' responses to it can be submitted to Your Honor more in advance, further in advance of July 6th than the current schedule allows. And then if we can agree on something, or if we can't, we will let the court know that. And I'm still going to ask the court to look at its calendar and suggest a hearing date, if necessary, on what I think can fairly anticipate will transpire. Again, because the media has requested that their cameras be present at every hearing, and it would seem to me that they would not miss the opportunity, from their point of view, to broadcast the preliminary hearing.
Thank you, Mr. Novak. I appreciate you addressing those or bringing those concerns
So we'll
up.
bring that back to the court at the appropriate time today.
Thank you, Mr. Novak. Does the state wish to be heard on this issue?
Yes, thank you, Your Honor. Christopher Ballard on behalf of the state. Just like to point out that even assuming that there's a request for electronic media coverage, which the state fully assumes there will be, and that the court grants that request, the equities as far as whether or not to stay things to allow the defendant to then appeal that ruling, that's really not going to change. The circumstances that the court's already articulated in its order today, those equities really aren't going to change between now and the preliminary hearing. And the appropriate procedure for reviewing a court's orders on electronic media coverage is not to pause the trial proceedings and allow defendant to seek interlocutory review of every order. The defendant can certainly do that. He has the right to do that, but that's not the appropriate remedy. I just remind the court of the United States Supreme Court statement in Chandler versus Florida, where it said that the appropriate safeguard against potential prejudice from pretrial publicity is the right to demonstrate that the coverage compromised the ability of the particular jury that heard the case to adjudicate it fairly. So defendant's claiming he doesn't have a remedy. He does have a remedy, and the remedy is to challenge the court's media order at the plenary appeal after this case is complete. Thank you.
Thank you, Mr. Ballard. All right, anything further before we move on?
Yes. We can take this up whenever the court wishes to take it up. And in addition to the two substantive issues which the court calendared for today, which is the hearing on the court's issuance of an order to show cause re contempt and the argument of a pending and fully briefed motion concerning the constitutionality of hearsay evidence in a preliminary hearing, Mr. Robinson filed with a motion to classify a document which I'll just describe as having privately been filed, seeking certification for an out-of-state subpoena for the preliminary hearing. And the court is nodding, so I understand that the court is aware of it.
I've reviewed that.
Okay, so again, because of timing issues, we would like at some point today to receive from the court a briefing schedule on that, because out-of-state enforcement of a subpoena, if the court certifies it, is obviously something that takes a little bit of time. And in light of the court's denial of the stay, for the moment, we have to assume that if that certification is granted at our request, and by the way, we've served counsel for the witness with that request as well,
Okay.
that we need time for an out-of-state counsel to appear in the appropriate jurisdiction and get an order enforcing that. I can't imagine that if the court granted the certification that there's going to be an issue about serving the witness, but we don't have a valid subpoena unless Your Honor certifies the application and then a court in the appropriate jurisdiction enforces it.
Thank you. And I note that that was filed last night around 8:04 p.m. Is
It
that
was.
what you're referring to?
Yes, that's exactly what I'm referring to.
All right. Thank you. The court will take that under advisement and figure out. Court will address that at some point today.
All right,
Thank
thank
you
you.
for bringing it to the court's attention, Mr. Novak. All right, let's continue on. Counsel for the state, could you provide a brief status update regarding discovery?
Yes, discovery continues to roll in and be processed and provided to the defense on Tuesday, June 9th, 2026. We sent 11 additional items to the defense.
Oh, Mr.
Thank
McBride, if you wouldn't mind starting over, and yeah, that's where the live mic is. Thank you.
Understood, thank you. Ryan McBride for the state. As of June 9th, 2026, we sent 11 additional items to the defense. 10 of these items were notebooks that were obtained and requested from the defense in a discovery review. One is an 1102 statement that was provided in preparation for the preliminary hearing. This is everything, essentially everything we have from the investigative agencies to date. The percentage provided to the defense is approximately 100%.
Thank you, Mr. McBride. All right, turning to the defense motion for an order to show cause for alleged contempt of court. This is set for an evidentiary hearing and argument. The court has reviewed the briefing submitted, and each side will be afforded 90 minutes to present evidence and argument. If defense intends to reserve time for rebuttal, counsel should plan accordingly. Following argument by defense or a presentation of evidence, the court will take a 10-minute recess and then turn to the state. Because this is the defendant's motion, the defense will proceed first. Mr. Novak.
Thank you, Your Honor. Mr. Robinson would first ask the court to direct Mr. Ballard to take the witness stand.
All right, Mr. Ballard, if you wouldn't mind coming forward and being sworn in.
Do you solemnly swear that the testimony you shall give in the case now pending before the court will be the truth, the whole truth, and nothing but the truth, so help you God?
Yes.
All right, Mr. Ballard, if you wouldn't mind getting situated to your left are water bottles, and after you're seated, if you wouldn't mind pulling that microphone close to you to ensure that the record picks up your testimony. Thank you. Mr. Novak, it's your witness.
Thank you, Your Honor. Mr. Ballard, what are your formal titles within the Utah County Attorney's Office?
I am the general counsel and public information officer.
Okay. You're testifying here today because the court has issued an order to show cause regarding contempt of a court order. And so there's a white notebook that I placed up there. Do you have that, sir?
I do have it, yes.
All right. Why don't we first turn in that notebook, and Your Honor should have one as well. I passed it up
I
earlier.
don't.
I passed it up
Oh,
to
there
the
it
clerk.
is. Thank you. I now have it, Mr. Novak.
All right, thank you, Your Honor. Mr. Ballard, why don't you turn to Exhibit 8? And just let me know when you've seen it and had a chance to look at it.
I've seen it, thank you.
Okay, is this the order entered by this court on September 16th of 2025 entitled Protection Order Re Pretrial and Trial Publicity?
It appears to be yes.
All right. And Your Honor, I understand that a court exhibit doesn't technically need to be received into evidence. Of course, the record is what it is. It could take judicial notice of it, but I just think for completeness of the record, would the court mind if we ask the court to receive Exhibit 8 into evidence?
To the state, any objection? No objection. All right, and if you wouldn't mind, so if, as I turn to both parties, because your microphones are turned off, if you wouldn't just mind projecting a little bit more so the record picks it up.
No objection.
Thank you, Mr. McBride. All right, so is this going to be defense exhibit number?
8.
All right.
They're pre-marked, so we'll just stick.
Just sticking with those numbers. All
I
right.
think it's easier for the record than changing the order.
I appreciate that.
All right, thank you.
Defense exhibit 8 is admitted and may be published.
I think. And Mr. Ballard, did you read this order either the day it was entered or shortly thereafter?
Yes,
So you were aware of it shortly after it was entered, correct?
yes.
All right. Why don't we also turn now to Exhibit 9? And same question, please let me know after you've had a chance to look it over.
I've looked at it.
All right. And is this an order clarifying, let me be more clear, an order of this court dated December 15th, 2025, clarifying at the state's request the order that is now Exhibit 8?
Yes,
And could the court receive into evidence, please, Exhibit 9?
No objection.
Thank you, Mr. McBride. With no objection being made, this is entered into evidence as defense exhibit 9 and may be published.
And, Mr. Ballard, with respect to these two orders, would you agree with me that subject to the clarification, these orders track Supreme Court Rule of Professional Practice 3-3.6.
Yes, they track that rule. They require both parties to abide by that rule.
And would you agree with me that you are a prosecutor also subject to Rule 3-3.8?
Yes,
And that everybody in your office is a prosecutor under the, within the meaning of 3-3.8?
the attorneys in our office, yes.
The attorneys in your office, right. And, again, Your Honor, these are rules of professional practice, but I am going to ask the court to receive into evidence for purposes of this hearing both Exhibit 10, which is a true and correct copy of Rule 3-3.6 with its comments, and Exhibit 11, which is Rule 3-3.8 with its comments.
No objection.
With no objection from the state, defense exhibits 10 and 11 are admitted and may be published.
And Mr. Ballard, were you familiar with these rules prior to the court issuing the orders, which have now been received as Exhibits 8 and 9?
Yes,
All right. So would you agree with me that you knew what was required under the court's pretrial publicity orders?
yes,
Did you have any inability to comply with those orders?
no,
All right, Mr. Ballard, would you look at Exhibit 2, please? And again, please let me know when you've had a chance to look it over and familiarize yourself with it.
I've looked at it.
And do you recognize this to be an email that you sent to counsel for Mr. Robinson on December 22nd, 2025?
Yes,
And the subject of this email was your notice of intent, the state's notice of intent to conduct non-destructive testing, correct?
correct.
All right. Your Honor, before I go any further, could the court please receive into evidence Exhibit 2?
Mr. McBride?
If I can have just a moment.
All right.
No objection, but as it goes to publication, this includes email addresses. If this is made public, those email addresses should be redacted.
All right. Mr. Novak?
We will provide the court with a redacted version of the exhibit that masks all of the emails that are, email addresses that are listed at the top of the exhibit.
All right. Based off the state's not making an objection, but requesting a redacted version with removing emails, Defense Exhibit 2 is admitted.
Thank you. So, Mr. Ballard, just so the court, because the court has probably never seen this email, I want to go over with you the context and the purpose of this email. The state had determined back in this time period, which is December of '25, that it wanted forensic examiners to do some further testing of a bullet, jacket fragment, and lead fragments, correct?
Yes,
All right. And under a prior order of the court, it was the state's responsibility to notify Mr. Robinson's defense counsel of any testing, which may, let's just say, change the nature of the physical evidence.
Correct.
All right. And so what you were doing in late December of '25 was notifying us privately that the state intended to conduct some additional testing, correct?
Correct.
And you state in this email that the reason why you don't want to publicly file this notice of intent to conduct further testing, at least at that time, was because of a comment to Rule 3.6. That's the same Rule 3.6 that the court has received into evidence as Exhibit 10, correct?
Correct.
And what you say is that the comment to Rule 3.6 of the Utah Rule of Professional Responsibility lists, quote, "the performance or results of any examination or test," close quote, and, open quote, "the identity or nature of physical evidence expected to be presented," close quote, "as subjects to avoid in public comments." Those were your words, right?
Correct.
And then I would also now like to ask you to look at Exhibit six. And I know I will sound repetitious, but please look it over and let us know when you've reviewed it.
I've reviewed it.
And is this an email that you sent to one member of Mr. Robinson's defense team, and then it appears that it was copied to other attorneys in your office?
Correct.
Your Honor, before I go into the details of it, could the court please receive it into evidence as Exhibit 6 with the same proviso, which is that we will provide the court at a later time with a redacted version that masks the email addresses?
No objection, but the email addresses are not included here, so,
Well, there is one at the very bottom,
Oh.
the signature for Mr. Ballard.
thank you. Excuse me.
No worries.
And Ms. Visser's below that as well, Your Honor.
All right.
But I think we're all on the same page about what to do.
It sounds like it. So that Defense Exhibit 6 is admitted with the following redactions being noted. Thank you.
Okay, so Mr. Ballard, in this email, you're informing us that the state no longer believes that filings concerning this additional testing from the state's point of view should remain private, correct?
I don't recall exactly the question that Ms. Visser had posed to me and that I was responding to, but the general, the email speaks for itself.
Okay, so the email says in the top paragraph, "But now that the court is involved, we do not believe that it is necessary to keep court filings private or even file redacted versions on this issue."
That's correct.
And this issue refers to whether the state can proceed with the further testing and Mr. Robinson's objections to the way in which the FBI wanted to do the testing, correct?
Correct.
I mean, basically, okay, so that's that dispute. What you say in the second paragraph is the ethical rules on pretrial publicity apply only to extrajudicial statements, right?
Correct.
And so what you're saying is that if we talk about physical evidence, testing that has been done, testing will be done, what the results of the testing are. If we talk about those, we meaning counsel who are subject to the rules and the court's orders in filings, we're consistent with Rule 3.6, right?
Correct.
But if we talk about them extrajudicially, that's prohibited under 3.6.
Correct. Unless we're talking about public records. Unless we're talking about a filing.
I'm not sure what you are modifying with the word unless, and I'm not trying to be difficult. Are you saying that you can make extrajudicial statements about anything you want that's in a public filing without violating Rule 3.6?
Rule
Is that what you
3.
mean?
What I mean is exactly what the rule allows, and that says that a lawyer may state information contained in a public record.
So if you file something that relates to issues that the rule says should not be commented upon extrajudicially, you're saying that that opens the door. The mere filing of something opens the door to making any extrajudicial statement that you want about that subject matter?
No, that's not what I'm trying to, no.
Okay, so why don't we let Mr. McBride ask you about that interpretation, because I'm going to move on to my next question. Why don't you turn, please, to Exhibit 1. And this is not an email from you, but it is one that you are copied on. It's actually a series, a couple of emails and a letter all together in Exhibit 1. Do you see all that?
Yes,
Okay, so first, let me ask you if you are familiar with the first 2 pages of Exhibit 1, which are a string of emails that basically start with Mr. McBride writing to, I mean, the email addresses are redacted. This is how we received it. But let's just say writing to many people who are in government or in law enforcement. Would you agree with that?
yes,
All right. And you're copied on that email as well, right?
yes,
All right. And then if you go to the 3rd page of this exhibit, and I should back up, Mr. McBride's original email to the law enforcement and government individuals I was referring to was September 15th of 2025, right?
correct.
Which is actually the day before the court entered its first publicity order, correct?
Correct.
All right. So if we go to the 3rd page of this exhibit, this is an email from you also a couple days before the court entered its September 16th, 2025 order. And you're writing to, well, are you familiar with this email?
Yes,
All right. And now let me ask you to look at pages 4 and 5. Those are the last 2 pages, Your Honor, of this exhibit. This is a letter written by Mr. McBride. Do you see that?
yes,
Dated also September 12th, 2025.
yes,
You're familiar with that one as well?
yes,
All right, so Your Honor, I would ask the court to receive into evidence, subject to any redaction which Mr. McBride thinks is necessary of emails, although I think they've all been redacted before produced to us. All 5 pages, we're asking the court to receive into evidence.
No objection.
All right, and this is Defense Exhibit 1, with no objection from the state, will be admitted.
Okay, so let's go back to page 1, Mr. Ballard. In his email, well, Mr. Ballard, you know generally who the people are who this email was sent to, right? The names behind the redactions?
Generally, yes.
Can I just refer to them as law enforcement partners?
Yes. I think that's accurate.
Some have email addresses that are local law enforcement agencies,
Correct.
including Utah County, correct?
Correct.
Spanish Fork,
Yes.
Utah Valley University, not a law enforcement entity, of course, but they have a law enforcement department at UVU.
Correct.
All right. And at least a couple recipients are with the FBI, right?
Correct.
All right. And so in this email, Mr. McBride says at the bottom, quoting Rule 3.6, there are certain subjects that are more likely than not to have a material prejudice effect on a proceeding, particularly when they refer to a criminal matter that could result in incarceration. You see that?
Yes.
And then he says these subjects relate to, and then on the next page, I want to draw your attention to Roman numeral 3, the performance or results of any examination or test, or the refusal or failure of a person to submit to an examination or test, or the identity or nature of physical evidence expected to be presented. Do you see that?
Yes.
Do you agree with Mr. McBride's assessment that Rule 3.6 prohibits extrajudicial statements about that topic or those topics?
Yes, this email represents our efforts even before the court issued its order to recognize that we had obligations under Rule 3.6 and that we were careful to abide by those obligations.
You were careful to inform law enforcement partners in the email of their obligations, correct?
Yes.
And then item 4, Roman numeral 4, also on page 2 of the exhibit, says, as another example of subjects that are more likely than not to have material prejudicial effect on a proceeding, any opinion as to the guilt or innocence of a defendant or suspect in a criminal case or proceeding that could result in incarceration.
Yes.
All right, now if we could turn to page 3 of the exhibit. This is an email from you to what I will describe, unless you disagree with me, as law enforcement partners. Do you agree with that?
Yes.
Asking them to carefully review a letter, which is the following page, from Mr. McBride, dated September 12th.
That's correct.
And that letter also, the letter is addressed to all personnel likely to make media statements regarding the Charlie Kirk case.
That's correct.
And the letter says, just below that, the Utah County Attorney's Office has an ethical obligation to, quote, exercise reasonable care to prevent investigators, law enforcement personnel, close quote, and others from making public comments which, quote, have a substantial likelihood of materially prejudicing, close quote, the trial process. That's what Mr. McBride wrote in the letter that you forwarded to chiefs and others, correct?
Correct.
And Mr. McBride's letter also says that prosecutors have a special duty to ensure that law enforcement and other officials adhere to these rules, citing Rule 3.8E, correct?
That's correct.
All right. And then Mr. McBride identifies statements that should be avoided. Or I should say, yes, statements that should be avoided. Do you see that? Statements should avoid the following, colon?
Yes,
All right. And there are 4 bulleted items there, right?
yes,
One of them, the third one is opinions about the defendant's guilt or proper punishment. You agree with that?
correct.
And do you agree with Mr. McBride that prosecutors have an ethical obligation to both avoid those themselves and to take special care to make sure that law enforcement personnel and others refrain from making such comments?
Yes,
And then the other statement that should be avoided are any other statements which could risk violating the defendant's right to a fair trial.
correct.
And would you agree with me that the any other statements phrase by Mr. McBride in this letter would include the more specific prohibition on extrajudicial statements about the performance or results of examinations,
Yes,
tests, yes? I'm sorry for interrupting you. The answer was yes.
correct, yes.
All right, I'm now going to turn your attention, please, to Exhibit 3. And I want you to take a moment to look at that. Tell me if you've seen it before, if you recognize it.
Yes, I recognize this.
Okay. Do you recognize this as an article published online by TMZ concerning this matter in which you are quoted?
Yes,
Okay. And my first question is, how is it that you came to be quoted? Well, actually, let me ask you this question. If you look on the second page of this exhibit, down toward the bottom, underneath the image of a black screen, the paragraph starts, Attorney Christopher Ballard tells us, comma, quote, and then there's a very lengthy, well, there's a few sentences in quotes. Do you see that?
yes, I do.
Okay. Did you tell TMZ that?
Yes, I did.
All right. So my question is, was that over the telephone? Was it an email? Was it a face-to-face meeting? How is it that your quote was communicated to a representative, a media representative of TMZ?
It was a telephone conversation.
And did you only have one telephone conversation with TMZ?
Yes.
And how was it that the telephone conversation came to be set up?
After the defense filed its motion to continue the preliminary hearing, there was a statement in that motion that garnered quite a bit of media attention. I came to be aware of that media attention and the headlines that that statement had generated. And there were quite a few media inquiries to our office based on the statement in the defense's pleading and the media stories that that statement had generated. TMZ was one of the media entities that called our office. I received an email from someone else in the office, I can't remember who it was exactly, that said, I got a call, they received a voicemail from a reporter at TMZ. That employee in our office forwarded me that voicemail, and the voicemail just basically said, we have some questions about these issues that statement in the motion to continue had generated. And so I returned the phone call.
Before you returned the phone call, did you have any discussions in your office concerning whether there should be extrajudicial statements about the issues that you're describing?
Yes,
Okay, and did you discuss that with Mr. Gray before you returned that phone call?
yes,
Did you discuss that with Mr. McBride before you returned that phone call?
no,
Did you discuss that with anybody other than Mr. Gray before you returned the phone call?
I know for certain that Mr. Gray and I discussed it. I have a vague memory that Mr. Grunander was involved at some point. But my memory is that Mr. Grunander was out of the office the day that all of this was breaking. And so he may have just been informed, brought into the loop after the fact by telephone. But I do recall that very early in the morning, I think it was of March 31st, because my memory is that the media story that launched all of this interest was posted, I think, late Monday afternoon, Mountain Time. And so by Tuesday morning, I was getting a lot of media inquiries. And I think Mr. Gray had also, my memory is that Mr. Gray received a phone call from Turning Point USA asking us if there was any merit to these media stories. And that's when Mr. Gray came into my office. My recollection, it was first thing Tuesday morning, and we discussed these media stories.
So Turning Point USA reached out to Mr. Gray, and Mr. Gray came to speak with you all about the same time that you received this forwarded voicemail from a TMZ reporter.
The voicemail from TMZ came later in the day.
Okay.
It was before noon, but it was a busy morning. There were a lot of media inquiries that were coming in that morning. And I know Mr. Gray and I met, I would say first thing Tuesday morning to discuss this issue.
And you and Mr. Gray had a conversation which led to a decision to return the phone call and make a statement to TMZ?
I did not discuss every media inquiry with Mr. Gray. I think I just generally told him, he brought up the issue that there were concerning media reports out there, potentially prejudicial media reports. I confirmed to him that I was getting media inquiries, and we generally discussed whether it would be appropriate to respond to those.
Okay. So did Mr. Gray know that you were going to call TMZ back?
No, I didn't discuss with him every media inquiry. Our conversation was general. We reviewed the requirements of Rule 3.6. I don't recall that we actually pulled the rule and read it, but we were familiar with the rule, and it's what it prohibits and what it allows. And we believed that under, I think it's subsection C, and also under the court's order, which specifically references subsection C of the rule, that we could respond, that this was potentially prejudicial media stories that we did not generate, and that the rule allowed us to be able to respond to those.
Were you aware of any extrajudicial statements by the defense which generated that media coverage?
No, and nor does the rule require that.
Well, that's your legal interpretation of the rule, right?
No, that's not my legal
I
interpretation of the
mean,
rule.
you were here when Mr. McBride argued to this court at the last in-person hearing that as long as there's some negative coverage out there, regardless of the source, that the state has leave to make extrajudicial statements on the same subject matter.
I heard that argument, yes.
All right. And that's a legal argument, right?
Yes.
Okay. All right, so here's my question. The information in the TMZ article, which purports to quote you on the second page of Exhibit 3, is that an accurate quote? Is that what you
Yes.
said?
Yes, it's accurate. I don't know that it's word for what I said, but it did not, it accurately captures my statements to the reporter.
Okay.
Mr. Novak, and I don't mean to interrupt you, but are you intending to admit exhibit number 3?
Yes, now that Mr. Ballard has said it's an accurate
Okay.
recitation of what he told TMZ, I would now ask the court to receive it into evidence.
Thank
No
you.
objection.
All right.
So in that quote, you tell this TMZ reporter what your views are on bullet fragment analysis, correct?
I wouldn't characterize it as my views, although I guess you could say it's my understanding in general of how bullet fragment analysis works.
And you're also commenting on the contents of the results of the testing when you say the fragment didn't contain enough detail for the examiner to say one way or the other. That's you basically commenting on the content of the results of the examination as you understand them, correct?
What I'm commenting, if you look at the first word, I say generally, and generally when you have an inconclusive result, the reason that you get that inconclusive result is you do not have enough detail.
Okay, but now you're again testifying about your understanding of bullet fragment analysis. And I'm just asking you, if you told this reporter, it's an extrajudicial statement, what your views are on bullet fragment analysis, and you're reiterating the conclusions in a report about bullet fragment analysis.
Objection, the statement speaks for itself.
Would you like to respond to that objection, Mr. Novak?
Well, I don't think that the answer to the last question was responsive, so I was trying to go back to the question. I guess I could have moved the court to strike the answer as non-responsive.
I'll sustain the objection.
And then in the same quote, Mr. Ballard, after talking about bullet fragment analysis, you say, there's just not enough there to determine whether the bullet was fired by a particular firearm. That's you telling a reporter what you believe the forensic testimony in a proceeding will be.
No, what I'm referring to is generally the types of circumstances that could produce an inconclusive result.
Okay, but you say there's just not enough there to determine whether the bullet was fired by a particular firearm. You're referring to the fragments recovered, correct?
No. What I'm referring to, you got to read that in context with the first sentence.
I'd like to read it in context of the next sentence, which talks about the evidence, in your view, being sufficient to prove that Mr. Robinson committed the murder. You're commenting on the bullet, and then you're commenting on your opinion about the sufficiency of the evidence.
So here's how the quotes came about. The reporter first asked me about these, the media reports and the misleading statement in the defense's motion that the bullet that was recovered did not match the rifle. And I responded to that and said, generally, when you have an inconclusive result, it can be caused by these general types of circumstances. The reporter then asked me, well, do you still have a case? And focused specifically on whether the additional media reports out there that the supposed inability to match the bullet to the gun was a bombshell finding for our case, and that it completely undermined the foundation of our case. So that next statement was responding specifically to that question as to how do these specific reports and the representation in the defense's motion, how does that affect our ability to proceed with this case?
I'm going to move to strike portions of the statement which mischaracterize the defense pleading as misleading. This court has never made such a finding. And we had argument about Mr. McBride's interpretation of what is and is not exculpatory evidence. I think we all remember the court's comments on that. So I think without trying to parse it too much, I just ask the court to strike the portion of the statement which characterizes the defense pleading as misleading.
Mr. McBride.
I think the court can take this statement, the testimony, for the value it deems appropriate. Testimony is asking about Mr. Ballard's perceptions, and that's what he's testified about. The statement in defense counsel's pleading is a matter of public record, and what we're really talking about here are the reports that were generated from that statement. So I would ask the court not to strike it, but to take it for the value it sees appropriate.
All right. The court recognizes first that it has not made a finding that the defense's, what defense presented in their motion was misleading, but also notes that this is the personal opinion of Mr. Ballard and makes that distinction. Thank you.
Thank you, Your Honor. So, Mr. Ballard, what you're saying is that you had, how long was the conversation with the TMZ reporter?
I think it was less than 10 minutes. It might have been just about 5 minutes.
And so the quote is a compilation of your statements over the course of the 5 or 10 minutes, right?
Right, and strictly in response to the questions that the reporter was asking me.
But you certainly had the discretion to not answer the questions, right?
Yes?
You could have said, I can't comment on specific evidence or what I think the quantum of evidence is, right? You could have said that.
Yes, and I didn't comment on any specific evidence.
Well, when you refer to the bullet, you're not talking about the bullet fragment removed from Mr. Kirk's body?
No, I'm talking about general circumstances that can produce an inconclusive result.
And isn't it fair, wouldn't you agree with me that one of the reasons why extrajudicial statements in many circumstances, and we assert in these, are prohibited is for exactly that reason, that reporters may, for either innocent or other reasons, take statements out of context or misconstrue things, and there's nothing you can do about it. Because once it's published, right?
Once something's published, it's published, yes.
Okay. Why don't we turn to Exhibit 4, please? And again, let me know when you've had an opportunity to look at that.
I've reviewed that. Thank you.
Okay. And did you have a separate conversation with a reporter from USA Today?
Yes, that was an email conversation.
So a reporter from USA Today wrote you an email and you responded.
Correct.
Did you preview your response with Mr. Gray?
No, again, we just had a general conversation about whether Rule 3.6 allowed us to respond to the prejudicial media stories that were circulating. And Mr. Gray and I agreed that it would be appropriate to respond under subsection C, and he left it to me to handle the responses.
Okay. So have you looked at the statements attributed to you in Exhibit 4?
Yes,
Are they accurate?
yes.
Did the court receive into evidence Exhibit 4?
Mr. McBride?
No objection.
All right, with no objection, Defense Exhibit 4 is admitted.
Thank you, Your Honor. The third page, Mr. Ballard, of Exhibit 4, which is a total of 3 pages, so it's the last page. There's some paragraphs down at the bottom of the third page. On your copy, are they highlighted in sort of purple?
Yes,
And is the court's copy highlighted in purple?
It is.
All right. So, Mr. Ballard, you see the statement, I'm sorry, the paragraph, the second to last paragraph that says Ballard confirmed?
yes,
Ballard confirmed the FBI and ATF are adding information to the initial reports, which prosecutors expect will include data supporting the initial conclusions. Do you see that?
yes,
All right. Is that an accurate recitation or summary of what you said in your email?
yes,
And so what you're telling this reporter is something that you understand the FBI and ATF will be doing in the future?
yes,
And you're also telling this reporter what you think those reports will conclude?
yes. This was in response to statements in the defense's motion to continue the preliminary hearing, where the defense represented that they did not have the supporting data, the underlying data that supported the initial conclusions. And the reporter asked me whether that had been produced, and I was responding that I anticipated that the FBI would produce the data that the defense was requesting.
Was that a matter of public record at that time, that the FBI and ATF were, quote, adding information to the initial reports?
I don't believe it was a matter of public record, other than the defense had requested additional information, and I was confirming that we were facilitating that request.
You were telling a reporter that we had made a discovery request and that you were complying with it.
Correct.
But you were characterizing what the FBI and ATF were doing with their examination reports, right?
No,
It says the FBI and ATF are adding information to the initial reports. That doesn't sound to me like producing additional discovery. That sounds like,
Objection, counsel's testifying.
Counsel, would you like to respond?
I'll rephrase the question.
All right, so I'll
Would-
sustain the objection. You may continue.
Thank you. Wouldn't you agree with me that what you are telling this reporter is that forensic examiners are changing their reports or adding information to their reports, as opposed to your office is obtaining additional background materials related to the testing?
no,
Let's go to Exhibit 5, please. Exhibit 5, are you familiar with that?
yes, I've seen this article.
Did you have a conversation of any type with somebody associated with PolitiFact, P-O-L-I-T-I-F-A-C-T?
Yes, again, this was an email conversation with the reporter that's credited with the story in Exhibit 5.
And on page 2, about a third of the way down, there's a paragraph that starts with quotation marks, "when the results of a bullet fragment." Do you see that?
Yes,
And that's a quote attributed to you, correct?
correct.
And then after identifying you, there's another quote attributed to you.
Yes,
And are those accurate reiterations of the email you sent?
yes.
Could this exhibit please be received into evidence as Defense Exhibit 5?
No objection.
Defense Exhibit 5 is admitted.
And in this second quote in this paragraph, your quote is saying there just aren't enough marks on the fragment to make a conclusion one way or the other, whether the bullet fragment was fired by the particular rifle.
That's what that quote says, but you have to read it in context with the previous sentence.
So it's your testimony that you're not referring to the rifle found by law enforcement at UVU, and you're not referring to the bullet fragment taken from the decedent's body? You're making a general statement about bullet fragment analysis?
Correct.
How did you end up appearing on Fox and Friends News and being interviewed?
Like many other media organizations, Claudia Cowan from Fox News emailed me, asked if I had any comment about the defense representation and its motion to continue and the media stories surrounding that. And I agreed to do a Zoom interview with Fox.
And did you discuss that with Mr. Gray before you did?
Not that again, I didn't discuss any of the specific media requests with Mr. Gray. We had the understanding that I should respond to the media requests as they came in.
How many media requests were there?
My memory is 8 or 9.
Okay, so you had a telephone call with TMZ, correct?
Yes.
And you had email communications with USA Today and PolitiFact,
Yes,
and you were asked to appear for a video interview by Fox and Friends.
yes.
Are there any other media entities who you communicated with directly in any of those ways? Parenthetically, because we're only aware of these 4.
Like I said, I think there were at least 8.
8 requests.
Yes, and I responded to all of those. I had a telephone conversation with a correspondent for NBC. I can't remember exactly all of the other news organizations that had contacted me.
Did you in any way collect the resulting news stories in which you are quoted?
No, I have some of them. I didn't make a search to find everywhere that I was quoted and collect those.
Okay, we would like, Your Honor, to show Mr. Ballard Exhibit 7, which is a video. And Ms. Visser is going to help us. Thank you. May we publish Exhibit 7?
Well, not before it's admitted.
Okay, so-
If you want
So we'll show it to Mr.
lay
Ballard.
foundation, Sure.
We'll show it to Mr. Ballard, and maybe if the clerk could just show show it to the witness before it's published. Mr. Ballard, can you look at the screen, actually?
It's going to take a few seconds. It's flickering while it syncs.
Thank you for your patience, Your Honor. Should we, silent for a moment?
All right, it looks like
Without
it's
sound.
on the screens.
Okay, so we're going to actually, because of the court's ruling on publishing it, we're going to show it without the audio and ask Mr. Ballard if he recognizes it.
All right. Looks like our screens went off here, so
Mr. Ballard, is your screen on?
Now
It's
it
on,
is.
Okay.
and it's playing.
Can Your Honor see it?
Yes, thank you.
Okay. All right, why don't we stop for a second? Mr. Ballard, is that you?
Yes, it is.
All right, do you recall doing this interview?
Yes,
Did you watch this interview after you participated in it?
I watched this story, yes.
Okay. Is this, as best as you can tell, an accurate digital copy of that broadcast where you were interviewed by Fox and Friends?
I haven't heard the audio, but I believe it is, based on what I've seen.
Okay, well, I'm going to ask the court to receive it into evidence, and if Mr. Ballard thinks that the audio is inconsistent with what he previously said, we'll withdraw the exhibit.
With that proviso, no objection.
All right. Defense Exhibit 7 is admitted and may be published.
Thank you. We'd now like to play it. And just so Your Honor knows, the entire thing is about 2 minutes and 12 seconds.
All right, thank you.
Rather than trying to cut it up, we'll just play the whole thing. With audio. Maybe.
Well,
Actually, and now we can publish it, so all the screens can be on, right?
it's on the screen, it's just the audio isn't coming through.
It says it's connected to the HDMI.
This is always the tricky part with technology.
Piece of evidence, the bullet that killed the
Do you want to
conservative
restart it now
icon. In a new defense filing, attorneys for Tyler
Killing Charlie Kirk, while pushing to delay an upcoming trial hearing as new details come out surrounding the ballistics report.
Claudia Cowan joins us now with the latest. Good morning, Claudia.
Good morning, Lawrence and Brian, and also to you, Rachel. Nearly 7 months after Charlie Kirk was assassinated, lawyers for his accused killer are attempting to cast doubt on a critical piece of evidence, the bullet that killed the conservative icon. In a new defense filing, attorneys for Tyler Robinson say an ATF summary report, quote, was unable to identify the bullet recovered at autopsy to the rifle allegedly tied to Mr. Robinson. But prosecutors say that report is inconclusive and doesn't rule out a ballistics match to the rifle Robinson allegedly used or to any other firearm.
The examiners were not able to find enough detail on the fragments to be able to make a determination as to whether or not they can tie the bullet to the rifle.
Law enforcement sources tell Fox that when the bullet hit Kirk, it struck.
Mr. Ballard, was that your statement on Fox and Friends?
That was the statement that they chose to play.
Was that the
yes.
statement you chose to make?
Yes.
And aren't you talking in that statement about the bullet fragment at issue in this case?
I prefaced that statement with the preface that I put on my other statements was that I'm not going to talk specifically about specific test results, but generally when there is a inconclusive result, these are the circumstances that could produce an inconclusive result.
So your testimony is that the statement that you just made to Fox and Friends is not referring to the bullet fragment in this case?
Right.
That's your testimony?
Right.
So obviously, your office, Mr. Ballard, and apparently TPUSA were concerned with what I'm going to refer to as the media spin on the contents of the motion to continue, correct?
Can you
Your
rephrase
office
that?
was concerned, and TPUSA expressed concern about the way the media was, I'm just going to use the word spinning, I think we all know what that means, the contents of the motion to continue.
I can't speak for TPUSA because I wasn't privy to that phone call. But our office was concerned, yes, about the prejudicial media reports.
So my question is whether the goal of these interviews was to influence the reporting, or was it to change the what you were concerned was the public perception of the case?
The goal of these interviews was to respond to the specific media inquiries that were being generated by the misinformation that was circulating about the bullet testing.
But there's a reason why counsel who are subject to the rules we're talking about here, and especially prosecutors subject to these rules and the court orders, choose to engage in extrajudicial statements. I understand your position is it's an extrajudicial statement which is permissible under the court order and the rules. I don't agree with you, but I understand that's your position. So what I'm just asking you about is what you hoped to accomplish. Was it to change the media content, or was it to influence the public perception of the evidence in this case?
Objection, asked and answered.
Mr. Novak, would
I
you
don't
like?
think I asked that question. Or if I did, the answer wasn't responsive. Mr. Ballard's response to the last question was, the goal was to respond to media inquiries. Was that the only goal, just to respond to
Hold on,
media
hold
inquiries?
on.
I'm sorry.
Counsel, I need you to rule on the objection before
Absolutely.
we move forward. I'm going to overrule the objection and allow that question to be answered.
The goal was to respond to the substantial undue prejudicial effect of the media stories.
What evidence do you have that there was undue prejudice? We haven't picked a jury yet.
The evidence that the reason that we were concerned about those statements is that it was producing we were concerned about the media stories that were saying, first of all, that the bullet in fact did not match, and that therefore we had no case, that we had brought a groundless prosecution. That was our concern.
Which is an issue that can be addressed through jury selection, correct?
That's one way. Yes.
It's an issue that could be addressed through an expanded jury questionnaire, correct?
Yes.
It's an issue that could be expanded through additional peremptory challenges if the court deems it appropriate, correct?
That's another way.
It's
Yes.
an issue that could be addressed through individualized voir dire, correct?
Yes.
It's an issue that could be addressed under the appropriate circumstances through a change of venue, correct?
Perhaps.
A couple more questions, and then if I have any more time, I'll reserve it.
You have 28 minutes remaining.
Oh, wow.
So,
Ms. Visser scared me. Before you decided to return these phone calls, answer these emails, and accept an invitation to appear on Fox and Friends, did you ask this court to clarify its order in light of the way the media was interpreting the motion to continue?
No.
Did you reach out to anybody in Mr. Robinson's defense team and say, you know, whether you guys did this intentionally or unintentionally, the media has misinterpreted your pleading, can we do something about that judicially?
No.
As opposed to extrajudicially?
No.
I have no further questions for Mr. Ballard.
thank you, Mr. Novak. Mr. McBride.
Oh, yeah, sure, I'm sorry.
I think I got everything anyway.
Hey, Mr. Ballard, I wanted to ask you a little bit of follow-up from what defense asked you. First off, I want to ask you, did you intend to violate the court's order in this case?
No,
Do you believe you violated the court's order in this case?
no,
Did you take actions to avoid violating the court's order in this case?
yes,
And do some of those actions include being familiar with the order,
yes,
being familiar with Rule 3.6,
yes,
limiting your statements to the media to those necessary to address the issues prejudicing your client?
yes,
Did you include a statement in some of your statements that the defendant was entitled to a presumption of innocence?
yes,
And a statement that the jury would decide the defendant's guilt as the finder of fact in this case?
yes,
On March 30th, at about 4:43 our time, did the Daily Mail run a story entitled "Bullet Used to Kill Charlie Kirk Did Not Match the Rifle Allegedly Used by the Suspect Tyler Robinson"?
yes,
I'm showing you on the screen. Can you see on the screen?
yes,
Exhibit 22?
22,
Yes. Excuse me, Exhibit B.
okay, yes, I see Exhibit.
And is this Exhibit B to the filing, the state's opposition to the motion to continue, what was the title of this?
I assume that, let me see the first page.
State's opposition to the motion for an order to show cause for alleged contempt of court in this case?
Yes,
And is Exhibit B that Daily Mail story that you referred to just now?
yes,
Was this the first story that reported, that generated all the media that has brought us to this stage in this case?
that's my understanding.
And after that story was published by the Daily Mail, are you aware of whether other outlets published similar stories?
Yes,
I'd like to turn to Exhibit C in that same pleading.
okay,
And for the court's record, this is docket 510, Exhibit C. And this is a USA Today article, is that right?
yes,
And the title is, "Does the Bullet Match? Key Issues Emerges in Charlie Kirk Murder Case," correct?
correct.
And I now want to turn to Exhibit D to this pleading. And this is an article by People, is that correct?
Correct,
Also published on March 31st of 2026.
yes,
And the title here, will you read that title?
bullet that killed Charlie Kirk doesn't match Tyler Robinson's rifle, his lawyers claim.
Right, I now want to turn to Exhibit E to the pleading. And this is a CBS News article, also published March 31st, 2026, correct?
Yes,
And will you read the title there?
Charlie Kirk's accused assassin's lawyers question link between bullet from autopsy and rifle found near scene.
I now want to turn to Exhibit A to your pleading, or to the pleading that we've been talking about. First, updated the next day, April 1st. Will you read the headline there?
How one headline shaped the narrative way that we were relying on that was there was no grounds for us to be able to rely on that piece of evidence, that evidence didn't support our case, and because it was a key piece of evidence, that we did not have the evidence to be able to proceed in this case.
And did that make you concerned your client might be, your client's
Mr.
right to?
McBride, let me stop you. There may be an issue with the audio being transmitted, so I just want to make sure that's remedied, and then we can continue once we confirm it's functioning as it should.
Thank you.
All right, do you want to?
Testing, 1, 2, 3, testing.
Mr. McBride, we can continue.
Thank you. Were these reports that we've gone over in the last couple of minutes, these news stories, were they accurately reporting what the evidence was in this case?
No.
And did that cause you concern about whether it would affect your client's right to a fair trial?
Yes, it did, because not only were those in those other articles.
When you received those calls, you testified that you and Mr. Gray had spoken about this, you'd spoken about Rule 3.6 in the court's order. But when you received those calls, you had the option, as you testified in direct examination, of just saying no comment, correct?
Right.
Would a no comment, how do you believe that response would be received by the public if the media states, we reached out to the Utah County Attorney's Office, when they were asked for comment, they responded, no comment?
Objection calls for speculation, relevance.
Mr. McBride?
The question here is whether or not Mr. Ballard responded as a reasonable attorney would under Rule 3.6C.
Could you repeat the question? I just want to make sure I'm processing it properly.
How do you believe the press would, or how do you believe the public would receive a story that had the response from the Utah County Attorney's Office as no comment?
I'm going to sustain the objection because it's asking for him to perceive what the public would perceive, and that does go to speculation.
I'll attempt to lay more foundation. Does the public's perception matter as it relates to your client's right to a fair trial?
It can, yes.
And is the public's perception ultimately what the public's, and even more particularly, the potential jury pool's perception, what matters when we're talking about prejudicing your client's rights?
Yes.
And so, isn't it true that you have to make a judgment about how the public is perceiving the media statements?
Leading.
This is
Well, it's
cross-examination.
cross-examination, so I'm going to overrule that objection.
Yes.
Did you believe a no comment response would cure the prejudicial effect of the media stories?
No.
Did you believe it would actually potentially increase the prejudicial effect of these stories?
Yes, especially given the kinds of stories that were circulating there, like that our case has a fundamental problem, that this is a bombshell, and for us to say no comment or to not give a response would feed the, my concern was that would feed this idea that the state really does not have sufficient evidence to proceed.
Okay, thank you. You mentioned before responding to these requests, you spoke with Mr. Gray about the requests and about the media that was out there at the time. Why did you speak with Mr. Gray about that?
Because we recognized that this was a significant issue and that we needed to figure out how we were going to respond to that.
And was part of that to determine whether you could ethically respond?
Yes. I think that the conversation was, should we, and can we, and should we?
I want to refer you to the court's order, the pretrial publicity order, and that's published on the screen in front of you. Do you see that?
Yes.
Will you read the last sentence of that order? This is the order dated September 16th, 2025.
It says, this order does not prohibit lawyers from making statements permitted by Rule 3.6, C, Utah Rule of Professional Conduct, 3.6, sub B, sub C.
Based on the language of this order, did you believe that it prohibited you from making public statements?
No.
Did you believe it prohibited you from making public statements that were allowed by 3.6B?
No, it allowed me to do that.
And same question with regard to 3.6C. Did it prohibit you from making statements under 3.6C?
Objection, he's asking the witness for a legal conclusion.
Did you want to respond, Mr. McBride?
No. I disagree with that objection, but I think the court can rule on that without response.
Well, I'm going to overrule the objection because that was fodder for the direct examination. It was addressed. He was asked about that, and so this is cross-examination, and that door has been opened.
Okay, let's look at 3.6, Rule 3.6. And that's up on the screen in front of you. I want to go through those particular statements or particular subsections referred to by the order, 3.6B and C. There's a couple of highlights here on the screen in front of you. Is that up on the screen in front of you?
Yes, I see those.
If you look at 3.6B, will you read those two highlighted portions? That's B, basically B and B2.
Yes. It says, notwithstanding paragraph A lawyer may state information contained in a public record.
Okay. Now, before going to 3.6C, let me ask you, on direct examination, defense counsel had a line of questioning about whether you can talk about anything that's in the public record extrajudicially to the media. You began to answer that question, but you weren't given the chance to finish your answer. Under 3.6B, will you talk about your understanding of what you can talk about that is in the public record?
My understanding of that, the language of the rule is that if there is something that's contained in a public court filing, that that I can comment on that extrajudicially.
In this circumstance, was the statement that generated this in defense counsel's pleading, that the ATF was unable to tie the bullet to the gun, was that in a public pleading?
Yes.
And the report that they made that statement from, the ATF ballistics report is what I will call it, was that in a public pleading?
It was. The defense attached that report to their motion to prohibit testing, and the court had ordered that to be made public.
And that report was attached to a pleading in docket number 284. Is that your understanding?
I don't know the exact docket number, but it concerned, I think it was their January 9th motion.
Okay. And for reference, the court's order making that docket number public is docket 460, March 12, 2026. I want to go to the next subparagraph. Okay, actually, before I do, notwithstanding that this report was public by this time, the ATF ballistics report. Did you specifically comment about the ATF ballistic report and its findings in your statements to the media?
No, in fact, if you look at Exhibit 4, the highlighted portion there, I say, when I'm responding to the USA Today reporter, I say, the ethical rules prohibit, well, it says, ethical rules prohibit him from speaking publicly about forensic testing and results. And then I go on to say, but I can say generally that when you have an inconclusive result, these are the types of circumstances that might produce an inconclusive result.
Okay. Let's move to subparagraph C, 3.6C, which is up on the screen. Will you read the highlighted portion of subparagraph C?
Yeah, actually, it's not up.
It's
for
going to
some
take a
reason.
few seconds for it to render itself on the screen. Not just yet.
I could read it from the exhibit.
Let's go ahead and do that, if you don't mind. So the first full sentence of subparagraph C.
This is from Exhibit 10. It says, notwithstanding paragraph A, a lawyer may make a statement that a reasonable lawyer would believe is required to protect a client from the substantial, undue prejudicial effect of recent publicity not initiated by the lawyer or the lawyer's client. Want me to continue?
No, that's fine. So as you read that, is there anything, do you see any language in subparagraph C that requires that any other public, undue prejudicial, substantial undue prejudicial effect of recent publicity must be generated by a defense counsel or opposing counsel?
No.
Okay, I now want to turn to your particular responses. So after you met with all these responses, or all these media inquiries were coming in, you meet with Mr. Gray and talk about whether you should and could respond. The answer is yes, we're going to respond, we should respond. Then you actually make the responses, correct?
Correct.
I'm going to turn back to the pleading that we'd referred to, where we had attached many of the news stories. We have here exhibit, let's see if this is the right one, exhibit F. And this is, I think this also appears in defense counsel's binder.
Is it the USA Today story?
This is the New York Post story. I'm going to ask you to read the first two paragraphs here on this page. Actually, let me jump to page 46 here of the pleading. Will you read the first paragraph on page 46 of the pleading, Utah County Attorney's Office?
Yeah. Utah County Attorney's Office Prosecutor Christopher Ballard said he can't comment on forensic testing and results, but he said, quote, when the results of a bullet fragment analysis come back as inconclusive, that means only that the fragment did not contain enough detail for the examiner to determine whether the characteristics on the fragment were consistent with having been fired by a particular firearm, end quote.
And is that consistent with how you had attempted to respond to all the media outlets that made inquiries?
Yes.
And is that in fact your statement?
Yes, I can't say that it's exactly word for word, but that accurately captures what I was trying to convey to the reporter.
Okay. I want to go to Exhibit G to the pleading. This is a PolitiFact article entitled, "Does a Bullet Analysis Clear Charlie Kirk Suspected Killer? What an Inconclusive Result Means." I'd ask you to read that first full paragraph, starting with "when." Will you read that, please?
When the results of a bullet fragment analysis come back as, in quote, inconclusive, unquote, that does not mean that the rifle did not fire the bullet. Christopher Ballard, a spokesman for the Utah County Attorney's Office and part of the prosecution team, wrote in an email to PolitiFact.
Thank you. Again, is that accurate? Your
Yes,
memory? Same answer. You can't say word for word, but in essence, it's accurate.
right.
Now I want to jump to the TMZ article. And is this TMZ article here, this Exhibit I to the pleading, an article that quotes you?
Yes,
Let's go to page 58. And we talked about this quote previously. Defense counsel asked you about this. And the statement beginning with Attorney Christopher Ballard tells us, that paragraph, is that the same, is that quote starts with generally and ends with trial? Do you know if that is, if that quote is exactly how you said it to them?
the quote again comes from, I'm answering two different questions from the reporter. First, the reporter asked me about these claims that the bullet didn't match. And then he asked me, so do you still have a case? Basically, do you have enough evidence to proceed? And so I was first addressing the specific question about the bullet, the claim that the bullet didn't match, and then second, I was responding to this idea that because of the forensic testing, we couldn't proceed with this case.
Okay, thank you. I'll go to the next page, 59. And I'd like to ask you to read the first two paragraphs here on page 59.
It says, as we reported, Tyler's defense team argued there's a discrepancy between the ballistic evidence and the weapon prosecutors say is connected to Robinson. In a filed motion, they wrote, quote, the defense may very well decide to offer the testimony of the ATF firearm analyst as exculpatory evidence, unquote.
And then will you read that next line as well?
Yes. It says, but Ballard says this isn't expected to derail their case against Robinson.
Thank you. Now I want to go to page 60 of the same article, the TMZ article, and ask you to read these two paragraphs as well.
It says, he told us, quote, can't speak about specific evidence, but the evidence that we detailed in the charging document is a general summary of the evidence that shows Tyler Robinson committed this crime, unquote, end quote. And it says, Ballard added, quote, he is presumed innocent. The ultimate decision will be up to the jury. We believe we will be able to overcome his presumption of innocence, end quote.
Thank you. Now, defense counsel in one of their motions, they quoted the Standard, which is a Hong Kong agency, and did you look at that quotation to the Hong Kong or to the Standard?
Yes, when I saw that in the defense pleading.
Okay, And I've got that up on the page, on the monitor in front of you. It's page 8 of defense counsel's motion for the order to show cause. And this, there's the double indent here. Do you see that?
Yes.
Did you talk to the standard?
No, they did not contact me.
And it looks like they included some of your statements, but not all of them. Is that accurate?
It looks like they're referring to the TMZ article, and yes, they took some of the quotes, but not all of them.
Okay, thank you. If I can have just a moment. Okay, I wanted to refer you to Exhibit 4 in Defense Counsel's binder.
Okay?
Let's see, in that purple highlighted portion on the last page, the second to last paragraph, this was discussed a little bit earlier, but I wanted to make sure that this was clear. Will you tell us what you were referring to in this second to last paragraph? It reads, Ballard confirmed the ATF or FBI and ATF are adding information to the initial reports. The prosecutor expected will include data supporting the initial conclusions. Will you explain what that's referring to?
Yeah, my recollection is that the defense, is part of their motion to continue the preliminary hearing, as part of the justification for that motion, they had argued that they hadn't received all of the underlying data that supported the conclusions in the initial reports. And so the reporter was asking me about whether, had that data already been produced or whether it would be forthcoming. And I was confirming that the FBI was gathering that and would be providing that, the information that the defense requested.
Did you personally appear on Fox and Friends?
No, I did a Zoom interview that they used as part of that program.
And the video we watched earlier, is that the entirety of this portion of your interview that they used on that program?
Yes.
So you didn't go to New York and sit down with them?
Nope.
Did you actually ever leave the office and go on a media speaking tour?
No, all I did was respond as the media inquiries came in.
Okay. Thank you. I have nothing else.
Thank you. Mr. Novak, redirect.
Yes, sir. Mr. Ballard, isn't it correct that there was a point in time with respect to the pleadings in this case that the defense's motion to prohibit the additional testing without some safeguards to document it, record it, monitor it, was a private filing.
Yes, the defense filed it as a private filing.
And you initially agreed, meaning you on behalf of your office, that it should be a private filing because it dealt directly with forensic examinations.
No, we opposed the motion to keep that filing private.
But as you said in Exhibits 6 and second, Your Honor. Make sure I'm setting the correct exhibit. In Exhibit 6, that you initially hoped that the dispute over the testing could be resolved between the parties, right?
Yes,
Okay. And then we filed, meaning Mr. Robinson filed, a motion to get some control over that FBI testing because the FBI had basically said, we won't let a defense ballistic expert watch and we won't videotape it, right?
I wasn't privy to what the defense was saying, or the FBI lab was saying.
But you're aware of the dispute.
There was a dispute, yes.
The FBI wanted to do further testing on bullet fragments, and we were concerned that it would have a destructive effect on the evidence. And so we asked to have a ballistics expert observe the FBI testing, correct?
I know that you filed a motion.
We asked your office to arrange with the FBI for an outside expert to observe. Aren't you aware of that?
I know that you were requesting certain procedures.
Right, was to either be present or videotape it. Or maybe you don't know what the procedures were.
That sounds correct to me. I wasn't part of those negotiations, or
Okay.
that
And
discussion.
when the FBI didn't agree to let there be light on whatever they were going to be doing, as opposed to darkness, we filed a motion for judicial intervention, right?
Yes, you filed a motion.
And we filed it privately.
Yes.
And we argued to this court that it should be private because it addressed forensic testing not yet received into evidence and future forensic testing not yet received into evidence. And the state opposed that.
Objection, counsel's testifying.
Didn't we file that?
Oh, counsel, there's
I
an
did it
objection.
again.
Would you
Sorry.
like to respond?
I can rephrase it in the form of a question.
All right, I'll go ahead and sustain the objection and maybe rephrase.
Are you familiar with the reasons why we thought the forensic testing documents and the dispute should be filed and litigated privately?
I think I generally understand why you wanted that private.
And the state decided it should be public.
We decided to oppose that motion.
It was your position that it should be public.
Yes.
And then the court overruled or denied the motion to keep it private, correct?
Yes.
And so that then became a matter of public record which you believe you could make extrajudicial statements about.
I believe the rule allowed that, yes.
Now, your testimony is that you only intended to communicate to the media generally how bullet fragment analysis works, correct?
Yes, I was responding to those inquiries and being careful to stay within the confines of Rule 3.6.
But the media inquiries were not generally how is bullet fragment analysis conducted and what are the findings and what are the conclusions. The questions were about the bullet fragment analysis in this case, correct?
Yes.
Would you agree with this following statement? In the first few weeks of this case, there were many media stories emphasizing evidence of Mr. Robinson's guilt.
Yes.
So your interpretation of Rule 3.6, because of that, is that I could go on Fox and Friends or send emails to media entities or have telephonic interviews where I say on multiple occasions, it's my opinion that my client is innocent.
Objection, relevance.
Do you wish to respond?
Mr. Ballard has testified that he doesn't think that his his extrajudicial statements violate the rule. And he specifically referred to comment 4, which says any opinion as to the guilt or innocence of a defendant or suspect in a criminal case is not prohibited because of what he says is prejudicial pretrial publicity. And so I'm asking the obverse, which is whether he agrees that that means that I or somebody I hire could go on a speaking tour. I'm not saying you went on a speaking tour, but and proclaim my opinion that Mr. Robinson is innocent without violating this court's order or without violating the rules of professional responsibility.
All right. I understand the objection and the response. I'm going to overrule the objection as it's within the nexus of what's being addressed in this hearing and what's been brought up in both direct and cross-examination.
What I understand the rule to allow is for a lawyer to make statements that the lawyer believes are necessary to protect their client from substantial undue prejudice of media stories.
So if I think in good faith that my client has been, that there is already proof of undue prejudice against Mr. Robinson because of all of the media stories, without seeking any judicial intervention, without seeking an ethics opinion from the state bar, I can schedule media interviews, I can issue press releases saying it's my opinion that he's innocent.
I think your interpretation of Rule 3.6 is up to you.
I'm asking you if you agree with that hypothetical.
Repeat the hypothetical.
Without any findings by anybody at this point of undue prejudice, and based on the media coverage to date, which we are all familiar with, do you agree, well, is it your opinion that the rule permits me to go on Fox and Friends, or have telephone calls, or send emails, issue a press release that says it's my opinion that Mr. Robinson is innocent? And that if I did that, I would not be in violation of this court's order or the ethical rules that we've been discussing?
I don't see anything in the rule that requires previous findings about prejudice.
It's just your conclusion that there is prejudice. That's enough?
I believe that what's required is what the rule says.
Thank you, Your Honor. Appreciate the court's time.
Thank you. Anything further for this witness?
No.
Mr. Ballard, you may step down. Thank you. All right, to defense, it looks like you have about 20 minutes left. I didn't include the cross-examination against your time. We'll go to the state's time, but how would you like to proceed next?
I have a few questions for Mr. Gray, since he was mentioned in the testimony from Mr. Ballard, and the OSC was returned against Mr. Gray as well.
Would you prefer to take a 10-minute break, or do you want to keep going? I'll defer to you.
I think a 10-minute break would be great.
All right.
Thank you.
Court will be in recess for 10 minutes. We'll come back at approximately 11:35. Off with Mr. Novak. Turning to Mr. Novak.
Thank you, Your Honor. I'd ask the court to invite Mr. Gray to the witness stand.
Mr. Gray, if you wouldn't mind coming forward and being sworn in.
You do solemnly swear that the testimony you shall give in a case now pending before the court will be the truth, the whole truth, and nothing but the truth, so help you God.
Mr. Gray, as you get situated, there's a bottle of water to your left. And after you're seated, if you wouldn't mind pulling the microphone to you so the record picks up your testimony. Mr. Novak, your witness.
Thank you, Your Honor. Mr. Gray, you're the elected county attorney for Utah County, correct, sir?
Yes, I am.
All right, and so you are responsible for essentially everything that happens in and through your office, correct?
Yes.
All right, and is Mr. Ballard still your chief of staff?
He is.
Does that mean he reports to you in the sense of an organizational structure?
Yes.
All right. And he's also the public affairs officer for your office?
Yes.
And he's also an attorney?
Public information officer.
I'm sorry, public information officer?
Yes.
And he's also a prosecutor?
He's general counsel. He helps with motions.
And he's one of the prosecutors in this case?
Yes.
All right. Mr. Ballard testified that you and he had some general conversations about media inquiries concerning the contents of Mr. Robinson's motion to continue the preliminary hearing. Is that correct, that you had some general conversations?
Yes.
Did you ever suggest to Mr. Ballard that one approach to these inquiries would be to confer with Mr. Robinson's defense counsel concerning the media's misinterpretation of what we had filed?
No, because the rules don't require it.
Okay. Did you discuss with Mr. Ballard whether the state should approach the court concerning what, if anything, the court would permit the state to do in light of your concerns?
Again, no, because the rules don't require it.
Do the rules prohibit it?
They do not prohibit it, but neither did his order require it, the judge's order in this case.
Nor did the rules prohibit you from, I'm
No.
sorry, nor did the rules prohibit you from reaching out to defense counsel and say, hey, you know, the media is spinning this in a certain way. We need to discuss correcting the record
No.
or clarifying media misinterpretations.
No.
All right. What about having a conversation with Mr. Ballard that went like this? Why don't we draft a statement, a single statement that we can send out to media entities and just be done with it?
I don't know that we had that conversation. I might have thought about that, but then you're getting even wider dissemination. I was unaware of how many inquiries there were. That actually might have the effect of going beyond who was inquiring.
But would you agree with me that one approach could have been to issue a statement which says the state stands by the allegations in the information and the significance of any evidence will be established in court proceedings?
I don't think that that would be sufficient.
It wouldn't have been sufficient to change the media spins. Is that what you mean?
Yes, I mean, what we're concerned about is prejudice to a prospective jury. And so that could be very damaging to our ability to do that. And so we wanted to ameliorate that
that prejudice.
And so is it the number of media stories and the content of the media stories which led you to conclude that the state was being prejudiced?
There was a potential to prejudice a fair trial, yes,
Based on
based on misinformation,
in the media?
yes.
But if it were accurate information, that would be okay with you?
I would not be correcting anything if it was accurate information.
Did you consult so we have the binding rule of professional responsibility here in Utah. Did you consult the ABA rules on this same issue?
No,
Are you familiar with them?
yes,
Are you familiar with the ABA rule that basically says extrajudicial statements by one party are only permissible where there have been extrajudicial statements by another party?
Objection, Your Honor. Relevance. What we're dealing with here is whether or not Mr. Gray, Mr. Ballard violated the court's order. It does not refer to the ABA rule.
I think it just goes to the state of mind of both of the individuals against whom the court has already returned to the order to show cause.
Well, help me understand the relevance as it relates to.
Well,
the
we have an
ABA.
ABA rule, which we cited in our reply brief, called Fair Trial and Public Discourse, cited at pages 4 and 5 of 6 pages in our reply brief at footnote 1, which points out that the ABA guidelines limit extrajudicial statements to those circumstances where an opposing party has already made extrajudicial statements. Whereas here, what the state is saying is that it can basically correct the record or make any public statements it wants as long as there's something in the public record, regardless of where it came from.
Why my concern as it relates to relevancy is whether that's binding and whether that's even applicable. I mean, there may be like a best practices, and I'm not saying it is or it is not, but as it relates to the issue before me, I don't see how that's relevant to help me with my finding in regards to the ABA.
Okay, so I think that so far Mr. Gray has said he's aware of it, and I think that's fine.
All right, thank you. So
Is
I'll
that-
sustain the objection. We'll move on.
Is that correct, Mr. Gray? You're aware of that
I
standard?
am aware of the ABA standard.
All right. Now, I'm just going to ask you the same question I asked Mr. Ballard toward the end. Would you agree with me that in the first few weeks especially, and continuing throughout this case, there has been substantial media coverage commenting upon Mr. Robinson's guilt?
Both guilt and innocence, yes.
Including, okay. And would you agree with me that he is entitled constitutionally to a presumption of innocence?
Absolutely.
Until the matter is submitted to the jury for deliberation?
Absolutely.
Okay. And so, do you agree with Mr. Ballard that in light of all of what Mr. Robinson's defense counsel view as prejudicial media coverage, prejudicing his right to a fair trial, that I can make public statements as to my opinion about his innocence without violating this court's order?
No, you cannot make an opinion about innocence or guilt, but I don't think that's what happened here.
Would you agree that the point of Mr. Ballard being interviewed over the telephone and sending emails and then appearing visually on Fox and Friends was to address media inquiries concerning specific forensic evidence in this case.
It was to ameliorate the prejudice resulting from misinformation from the media.
About a specific piece of evidence in this case.
Yes.
And you think that by crafting, that Mr. Ballard's efforts to control the conversation with the media by, as he testifies, just talking about forensic testing generally avoids the prohibitions in the rule?
Whether I believe that avoids the general prohibitions, I
Yeah.
think that's one way to do it.
I know that you did not seek any guidance from the court on this issue. Did you consider filing some sort of a motion or a request asking for clarification on how the court's pretrial publicity order governs this situation?
No, I thought the court's order was quite clear.
Because there was another point in time where the state did seek clarification of the court's order, right?
Yes,
And the court clarified it.
yes.
Thank you, Your Honor. I have no further questions.
Thank you. Mr. McBride.
Mr. Gray, do you believe that the presumption of innocence means that an attorney can never respond to prejudicial media?
No,
Did you intend to violate the court's order in this case?
no,
Do you believe you violated the court's order in this case?
no,
Did you take actions to avoid violating the court's order in this case,
yes.
such as you are familiar with the court's order?
I'm familiar with it, yes,
You are familiar with Rule 3.6, correct?
yes,
And you expected Mr. Ballard to limit the statements to the media to those necessary to address the issues prejudicing your client.
yes,
Now, you've been present for the testimony about the, what I'll call kind of a media frenzy about this claim that the bullet didn't match the gun,
yes.
right? As that media came out, did you meet with Mr. Ballard and discuss what to do about it?
Yes, my recollection is a little bit different from Mr. Ballard's recollection of it. What I recall is he came to me, told me that he was getting several media requests for that, and whether or not we should or could respond to those inquiries. So I spoke with him about it. I know I spoke with Chad. We discussed Rule 3.6, specifically subsection C, that indicates that we can, where we believe that there's a substantial likelihood of material prejudice. And so I ultimately told Mr. Ballard that, yes, he could respond to inquiries regarding that. And specifically our concerns. The media had reported, based on the motion to stay the preliminary hearing, it indicated only that it didn't indicate on the bullet, the defendant's motion, and didn't say anything about the actual report that said it didn't indicate or exclude that it came from Tyler Robinson's rifle and was therefore inconclusive. So based on our reading of that, we could correct that. This wasn't a matter of, deciding whether it's exculpatory or inculpatory. This was a matter of correcting what that ATF report actually said.
And particularly to your client's right of a fair trial, right?
That's right.
Okay. You said you're aware of the rule, you're aware of the court's order. Were you aware of any cases dealing with media and attorneys correcting misrepresentations by the media?
I was.
For example, do you have?
The Corey Richards case, actually, where lead counsel in this case was also lead counsel in the Corey Richards case. I was aware of their interview that they conducted before trial to correct what they perceived as misinformation.
Okay, so let me get that clear. Lead counsel in this case, Kathy Nestor, is that right?
Yes,
She went to the media in the Corey Richards case, is that right?
yes,
And with the purpose of correcting what she perceived to be misinformation in that case?
yes, from the media.
And did she make any comment about prosecution's duty to correct misinformation in that interview?
There were the entire team there, or at least 3 members of that team in that report.
Of the
And-
defense team?
Of the defense
Okay.
team. And between her and her other co-counsel, they indicated that they had hoped, I believe Ms. Nestor actually stated that she had hoped that the prosecutor would come forward to correct that misinformation, but because they didn't, they came forward.
And were you aware of that case and that interview on March 31st of this year?
Yes, yes, I was.
When did you become aware of that interview by Ms. Nestor?
Back in October of 2025.
Okay. Have there been other Have there been other circumstances in this case where you have declined and your office has declined to speak with the media?
Yes.
And if you declined in other circumstances, why did you not decline in this circumstance?
Because we were, again, it was media reports where they were saying that they were misrepresenting the actual report that's in the record. And, you know, that it did not match. That's not what the report said. Again, I'm not getting into whether it's exculpatory or inculpatory. What the report said was that the testing did not identify or exclude the bullet fragment as coming from the rifle, and therefore was inconclusive. And so we got those reports. In those other circumstances, we had persons concerned about what they perceived as misinformation. And my conclusion was, we're not going to go out there and talk about those things because, quite frankly, you know, I didn't know whether or not how the defense would use that information. And so I decided, no, we're not going to comment on that kind of stuff.
Okay, so there have been other circumstances where you said, nope, we're not going to talk to the media about X, Y, and Z.
That's right.
But in this case, you made an analysis and said, yes, we're going to talk to the media in this case because of how important the issue is.
Yes.
Nothing else.
All right. Mr. Novak.
Mr. Gray, I don't know anything about the Corey Richards case, so let me just ask you a couple questions.
Sure.
You had watched some sort of a media interview that you say that Ms. Richards' counsel conducted before trial.
Yes.
And did you think that was appropriate under the rules?
I think they went beyond what they could do, but I think it is appropriate under Rule 3.6 under the right circumstances like this case.
So it really depends what it is you say that puts you close to the line or over the line set by Rule 3.6 in the court.
Sure, I mean, you have to be careful in what you say. I mean, we do our very best to be careful.
And was your office prosecuting that case?
No,
Okay. Did the county attorney file anything with the court concerning those public statements, to your knowledge?
I'm not aware of that. I talked with her. She was the one that advised me of that, and that's why I became aware of it. But I don't know whether or not they decided to or not. There are many reasons why you may or may not file something. I know that she wasn't happy with it.
When you say she, you're referring to the county attorney?
Robert Olson from Summit County.
I see. And you don't know if Summit County sought any judicial review of those extrajudicial
Yeah,
statements?
I do not know.
Understood. Yeah, thank you, Your Honor. I don't have any further questions.
Thank you. Anything further for this witness? No. Mr. Gray, thank you. All right. Mr. Novak.
No further witnesses, thank you.
All right. To the state.
No witnesses, Your Honor.
All right. We can proceed to, I'll defer to the parties. Mr. Novak, you have about 8 minutes for argument. The state has a little bit more than that. So as the parties wish to proceed.
I'm prepared to do it now if the court wants to continue. Whatever works.
Yes, my intent is, we'll do that, then that will conclude this particular, as it relates to the OSC, and then we'll turn to the motion in limine as it relates to hearsay, giving the parties time to argue that, as the court has reviewed in detail the motions, which were detailed, and the court appreciates that. So we'll have a brief oral argument on that, and then we'll go to the last issue that Mr. Novak brought up and address that as well. All right, turning to Mr. Novak.
Thank you, Your Honor. And I want to be careful to be clear, at least from our perspective, that there are two issues here. One is whether the evidence supports a finding of violation of the court order by Mr. Ballard and/or Mr. Gray. And then the question, if the court does make that finding, is what are the consequences? So I'm going to really deal with the first part first and the second part second, unless the court wants to bifurcate it and issue its findings on whether or not there's been a violation, in which case, if the court finds that there has been a violation of the court order, then we can address the remedies.
We can address that today. Thank you. In regards to your argument and what you are advocating for.
All right, so the court would like to hear all of it at once. That's what I'm hearing. Okay. So first of all, the court's order concluding that there was a preliminary finding, that we had made a preliminary showing, identifies 3 elements to the contempt. And Mr. Ballard essentially admitted to the first 2 elements. He was aware of the orders, and there was no reason why he was unable to comply with them. So the third element is whether the order was violated. Now, I acknowledge that the court's order uses the word intentional, but I would ask the court to look again at our pleadings concerning whether intentionality is an element of the offense. And the reason why that's important is because many courts, as I cited in the brief, so I'm not going to cite all those cases again, say that where the order is in the nature of an injunction, the court doesn't need to make a finding of intent. Every order is different. This is an order enjoining conduct. And so if somebody violates, knows of, and has the ability to comply with an order enjoining conduct, and the order is violated, there is no need to show intent. However, what I will argue to the court is whether or not the court is going to add that element of intentionality, I think the evidence is clear that the violation was intentional. Or it was so reckless, and I will use the legal phrase extreme recklessness, that there's a very fair inference of intentionality. And I don't say this lightly, and this is one of those situations where lawyers and judicial officers sometimes cringe, but sometimes the cover-up is worse than the original conduct. I know we've all heard that before, and we all know what that means. But I find no credibility in Mr. Ballard's sworn testimony that he only intended to communicate with the media generally about bullet fragment analysis. He used phrases like "this bullet." He's responding to misconceptions in the media about what the defense said in its filing. He's talking about the bullet fragment analysis in this case. And I have trouble accepting Mr. Ballard's explanation that he really never said anything about the bullet fragment analysis in this case, especially, I mean, the most clear example, frankly, is his statement in Exhibit 7, which is his statement on Fox and Friends. Because he talks about this bullet, the bullet, the bullet. He's not talking in general terms. He's not talking in generic terms. He's not a ballistics expert, although in some of these exhibits you see that the journalists interviewed ballistics experts. Mr. Ballard is trying to influence public perception about examinations in this case. And I think to say, oh, I'm not talking about this case, I'm only talking about ballistics generally, is belied by the context in which the statements were made, the motive that Mr. Ballard and Mr. Gray admit they had in engaging in extrajudicial statements, and the content of those statements. Mr. Ballard also acknowledges that he made statements about future examinations and his expectations about what future FBI and ATF reports would say in this case. So even if Mr. Ballard has this, what he thinks is a safe harbor, oh, I was just talking about bullet fragment analysis generally, he is then saying, oh, and we'll have some more reports in this case soon that will clarify this. So he's actually talking about what he believes forensic experts will do and say in the future, which I think not only violates the rule in and of itself, but shows the overall problem with his excuse. The reason why we asked Mr. Ballard and Mr. Gray if you can turn this around and say, since there's been all of this negative media coverage, can I go on a public relations tour and state, in my opinion, Mr. Robinson is innocent extrajudicially, beyond the fact that he has a constitutional right to the presumption of innocence, which the prosecution has an obligation to embrace and uphold, is because if I can do that in response to media coverage, then this court's order and the rule are completely swallowed up. In other words, in a case where there is media coverage, which is not the result of interviews by the defense, I can go do those things, then this court's order has very, very little meaning. And Rule 3.6 has very little meaning. And that just can't be the way it works. So, at a minimum, their conduct was extremely reckless. And that, in the law, is the same as intent. But again, I don't believe that that's what this court has to make a finding in order to confirm the court's initial preliminary finding of a violation of this court's rules. It's interesting, Your Honor, that the state's attorneys have already decided that the recent media coverage about the bullet fragment analysis has prejudiced their case. Because they've been saying in this courtroom and in pleadings that we can't prove that any of the media coverage in this case has prejudiced Mr. Robinson. They've been saying, pick a better jury, have a better questionnaire. Maybe there's a venue issue, more peremptory challenges, individualized voir dire, and this court has said the same thing. But when it suits them, they say they've already determined that their case is prejudiced. And so they need to correct the perception in the jury pool so that they can have a right to a fair trial. And it's offensive to me, but it's deeply ironic that when it suits the state, we can't prove prejudice, and when it suits the state, they've already concluded that there's prejudice. Without even taking a moment to say to this court, we're very concerned about this. We weren't concerned before about all of the negative media coverage about Mr. Robinson and his life, but now we're concerned about the media coverage concerning this piece, and so, Judge, what are we going to do about this? I am confident that if the court received an inquiry from counsel that said, there's an urgent matter here, we'd really like to have a conversation with the court about what is acceptable under this court's order, this court would have convened a hearing. This court convened, as I recall, a conference call on like 6 hours' notice back in September when the court wanted to manage this case quickly because things were happening. And the court's staff got everybody on the phone, and the court made some decisions, and then those decisions were docketed. There's nothing that stopped the state from asking this court to either clarify its order or approve some press release, even if it was over the defense's objection, that would be consistent with Rule 6 and the court's orders and Rule 3.8. So now, in my remaining time, I'm going to go to the remedies. I think that the number one remedy in this case, Your Honor, is for this court to preclude the state from seeking the death penalty against Mr. Robinson. The court said at an earlier time that if the court found there were violations of its orders, that it could order somebody to do continuing education, it could impose fines, it could do all kinds of things under the civil remedies. That is true. But what we are talking about is the state, without any guidance from this court, going out and trying to influence the public perception of this case so that when people come into this courtroom, and they may be jurors in this case, they have been exposed to the state's extrajudicial statements about what the evidence will or will not show before the first witness is ever sworn to testify in the trial, before any exhibits are ever received into evidence. And as Mr. Ballard said, the media spin will never change. The media will do whatever the media wants to do, and I'm going to return to that as well. What was going on here was an attempt to influence the jury pool, because that's the only thing that cures the prejudice, is correcting what the state is concerned are the perceptions of potential jurors. And so that is the remedy that is commensurate with the extreme recklessness and the motives of the state. We asked this court to compel some discovery, but Mr. Ballard was quite frank. We need to change public perception of what the evidence is or might be before we ever pick a jury. There are other lesser remedies, but we've already been through proceedings concerning how to remedy the pretrial publicity, the electronic publication of these proceedings. And the court has already said in other contexts, we're gonna have a more thorough jury questionnaire. We're gonna have more voir dire. We're gonna have individualized voir dire. We're gonna have venue issues. I'm not saying that the court has promised to change a venue. That's not what I'm saying. But the court this morning said there may be an appropriate venue issue here. So there's no additional consequence for the state's misconduct here. We're already at the point where we've got to pick we have to much more carefully pick a jury because of what has happened in this case over the last 9 months. And now the state has compounded it horribly. We can't wait until we start picking the jury to find out what harm has been caused. So we think that's the first remedy. The others are the remedies that the court has already said are probably necessary in this case. I don't want to be flippant, but I don't really care whether Mr. Ballard attends a continuing education program or not. All I care about is my client's constitutional rights. And referring Mr. Ballard or Mr. Gray to the state bar, as Mr. McBride referenced, I'm not saying he suggested that, at the argument on the motion, doesn't protect Mr. Robinson's constitutional rights. Mr. Levitt's sanctions weren't affirmed by the Supreme Court until years after that case ended. That doesn't protect Mr. Robinson's rights in this case. I just want to say one other thing, Your Honor. One of the reasons why extrajudicial statements are strictly controlled is because lawyers can't control the media. We can send them an email, we can make statements on the phone, we can sit for a 15-minute interview. Journalists will cut and paste and shape articles to fit their purposes. And that's why it's extremely reckless to do what Mr. Ballard and Mr. Gray did. If they had put out a press release, especially one approved by this court, that said the state stands by the allegations and the information, evidence will be presented at trial, Mr. Robinson has the right to the presumption of innocence until the trial has concluded, we wouldn't have this problem at all. Because the media, all they could do is cut and paste pieces of a press release that would be totally in conformity with this court's order and rules 3.6 and 3.8. And so they let Fox and TMZ and other media entities cut and paste whatever was important to them. But that doesn't relieve them of the responsibility, and it also does not undermine what I think this court unfortunately needs to find to be true, which is that Mr. Ballard's attempt to say he wasn't talking about the ballistic testing in this case is simply lacking in credibility. Thank you, Your Honor.
And counsel, I do have a question for you. So hypothetically, if the court finds a violation, do the interests of justice require a proportionate sanction?
Yes. And I think in light of the remedies that this court has already said are going to be necessary in this case, the sanction that I've suggested is proportionate, and it's in the interest of justice.
Thank you, Mr. Novak.
Thank you, Your Honor.
Turning to the state.
Your Honor, I'll start with defense counsel's assertion about credibility of Mr. Ballard. I view the evidence completely different. It seems to me that Mr. Ballard was extremely credible. His statements that were reported through several media entities all said the same thing, which were, I'm not going to talk about specifics of this case, but in general, when you have an inconclusive report, it means this. Did he say the bullet? Yeah, because he was referring to the bullet referenced in the previous sentence. And that was consistent throughout all of the media that we looked at. And the Fox News story, when you see that, you can tell it cut off the last word when it begins his next sentence. That's how quickly it starts. And so and that's consistent. His testimony that he was referring to a general inconclusive result is consistent throughout all media entities here. But the reality is it doesn't matter anyway, because Rule 3.6b says parties, attorneys can reference matters in the public record. And this report was, in fact, in the public record by this time because defense counsel attached it to one of their pleadings. The court ordered that it would be public, and it was public. What Mr. Ballard's efforts at being general rather than specific show is a measured and thoughtful effort to correct the unfair prejudice that faced his client, not an effort to prejudice the defendant. That shows a measured and thoughtful, deliberate approach, not an intent to violate the court's order. The statement about what future FBI reports would say, that's misleading. That is not what the testimony was. Mr. Ballard testified, I talked about what the future FBI and ATF reports may say, and that was in reference to the motion to continue the preliminary hearing that talked about the lack of discovery of underlying data supporting the scientific reports. That's what the testimony was. Despite what Mr. Novak may want to say here, we're limited to what the testimony is here, and that's what the testimony was. The hypothetical, where defense says, well, taking the state's position at face value, then defense counsel could get up and say, I believe my client's innocent. That's comparing two completely different things. Rule 3.6, the comment to Rule 3.6 says, attorneys should not be saying they believe someone is guilty or innocent, right? That's not what Mr. Ballard said. He didn't come up and say, I believe defendant is guilty. That's not what he said. And with regard to the prejudice to the case, right? Mr. Novak talked about, well, it's not consistent that when it's the defendant being prejudiced, then we can handle all this through voir dire and expanded veneer and all those things. But when it's the state being prejudiced, you can't. You have to actually correct the record. Well, there's a difference here. Well, the first question is, are they being prejudiced unduly? Under 3.6, that's the language, undue prejudice. Well, is it undue prejudice? When the evidence, and we all know this, everyone in this courtroom knows that media was misrepresenting the evidence here. That's what makes the prejudice undue, right? If there's a false narrative that's being pushed, that's undue prejudice. Under 3.6, that's when you step in and correct it. Now, that's why the comment to 3.5 or 3.6, comment 5 to Rule 3.6 is helpful, is because there are certain things that can create undue prejudice, such as an attorney's opinion on guilt. So if Mr. Gray had stood up at the initial press conference in this case and said, trust me, I am your elected county attorney, I believe the defendant is guilty, To correct that undue prejudice, yes, defense counsel could have got up and said, members of the public, it doesn't matter what the county attorney said, what the county attorney believes. What matters is the presumption of innocence, and we've got to wait for a jury and all of those things, right? But that would be undue prejudice, right? Not the fact that he's been charged with a crime, not that there's an affidavit of probable cause and the contents of that, not that there's pleadings in the case and the contents of those pleadings. And that brings me to the point of, this is why it's so important that attorneys satisfy the duty of candor to the court, is because when an attorney files something with the court, we all know an attorney has a duty to this court to have candor and to be honest in what they represent. Why? Because then when the media reports on it, there's some assurance that there's some validity to those statements. That's why some of this, what we're dealing with, is so upsetting, is because it generates from a pleading the claims that frankly was misleading, I think. And obviously the media all thought it meant what they said it meant. All right, with that, let me turn to, I think, what really is the crux of the issue here. You got to start with the standard. The standard of proof is clear and convincing evidence. In order to find Mr. Ballard or Mr. Gray in contempt, the court has to find by clear and convincing evidence that Jeff Gray and or Chris Ballard intentionally violated the court order. Now, defense counsel has taken issue with that intentionally language, but the issue they take generally comes from a case and a line of cases that predates the Von Hackey v. Thomas case, which is a Utah Supreme Court 1988 case, which promulgates the intentional standard. That same standard was reiterated in Sumner v. Sumner, a 2012 Utah Appellate Court case. These are cited in the state's brief, I should mention, as well as the Kohler v. Allen 2020 Utah Appellate Court case. That's the standard. Proof by clear and convincing evidence that these attorneys intentionally violated your order. In this circumstance, the defense can't prove, and I don't think the court can find, the actus reus, much less the mens rea, which is much more difficult to prove. When you look at the actus reus, these statements did not violate the order, which explicitly refers to Rule 3.6. That last line of the order says, right, this order does not preclude the attorneys from speaking to the media. See Rule 3.6b, right? 3.6b allows attorneys to talk about material in the public record. And 3.6c, which allows attorney to correct extrajudicial statements that prejudice their client's rights. It did not violate the rule because the reference to the test, the report from the ATF, was a matter of public record, docket 284, which is specifically allowed by the rule. But Mr. Ballard, in demonstrating his measured response, took an additional step to avoid potentially prejudicing the defendant's rights. Rather than saying, I'm going to read to you the report, media, that talks about this case, the bullet in this case, and the results. I'm going to read to you the report that says not only the part that the defense included in their pleading, that they could not tie the bullet, that they could not identify that bullet as having been fired from that gun, but they could not exclude it. And not only that, but they could tell this is a .30 caliber class round. Mr. Ballard did not do that. He could have under 3.6b, but he didn't. Why didn't he? Because he was taking a measured and deliberate approach to avoid violating this court's order, to avoid violating his ethical duties. Under 3.6c, he was correcting an unduly prejudicial media to protect his client's right. Why is it unduly prejudicial? Because it was false, right? This narrative that the bullet didn't match was false. Everybody in this courtroom knows that that narrative was false, and he was correcting that narrative. It's hard for me to think of a circumstance where 3.6c would be more directly at issue. We have here perhaps the most high-profile murder case in the world. Certainly one of the most high-profile murder cases in Utah's history that has generated extraordinary attention from the media and from the public. We have here, not only that, we have here reports that are that are misrepresenting the evidence and claiming that it completely exonerates the defendant. And those reports are false, right? Hard to see a circumstance where 3.6C would not be more at issue. So, Your Honor, I don't think the court can even find the actus reus here. I don't think the court can find that the statements that were made by Mr. Ballard violated 3.6B or 3.6C and therefore violated the court's order, much less that Mr. Ballard and Mr. Gray intended to violate the court's order. When it comes to the mens rea, the intent, you can see by the statements, by the testimony, that both Mr. Ballard and Mr. Gray were deliberate. They talked about Rule 3.6. They were aware of 3.6, 3.6C. They were aware of other cases where corrections of the record had been brought up, including by lead defense counsel here, where she corrected the public statements and said the prosecutor should too. And they made measured statements, Mr. Ballard made measured statements to the media that were deliberate and did not go beyond what the rule allowed. He did not say, I believe he's guilty. He did not say, like Mr. Levitt did, I believe my witness. We believe the witness. He did not refer to evidence that would not be admissible. He referred to evidence that was in the public record. Finally, Your Honor, I think in conclusion, the defense has not shown and the court cannot find proof by clear and convincing evidence that Jeff Gray or Chris Ballard intentionally violated the court order or violated the court order at all. As I mentioned before, we've taken this matter seriously. At the very outset, you can see that the state, the day the defendant was arrested, was sending out letters to the media, to police chiefs and the law enforcement agencies saying, be aware of these rules. If you talk to the media, you have to abide by these rules. We suggest you don't talk to the media. If you have questions, talk to us. You can see that we've taken this very seriously from the outset. We've taken it very seriously up until this date. We have a duty to justice and to our client to make sure that our client gets a fair trial and that the truth is out there. And this, of course, this issue has brought the issue front and center to us, and we've discussed it, and we've discussed how we can be absolutely certain that we do not cross the line. We don't want to cross the line. We want to stay as far away from that as possible. We believe we want the state, we want Mr. Kirk, we want his family, we want everyone, including the defendant, to receive a fair trial. We don't want to do this again. We want to do this right the first time. We believe we've done right this far, and we will exercise extreme care to continue to do right here, even if that means revising some of our protocols in interacting with the media.
Thank you, Mr. McBride. I do have one question for you. With reference to the final page of Exhibit 3 and in the context of correcting the record and evaluating undue prejudice, how does the state contend that Mr. Ballard's statement, and I'm quoting, "He is presumed innocent. The ultimate decision will be up to the jury. We believe we will be able to overcome his presumption of innocence."
Thank you. Yes, first off, we don't know the exact order in which this statement was received. But I think there's two things that are important here. One is the reference to he is presumed innocence, right? That shows that Mr. Ballard was intentional about making that clear, right? The jury will find guilt. That last statement, we believe we will be able to overcome the presumption of innocence. This is a reaffirmation of the state's certification under Rule 11 that we have the evidence to proceed with the case. In good faith, we believe we have the evidence to proceed with the case. Every attorney that files a pleading in this courtroom certifies that they believe the matters contained in that pleading are supported by evidence. And that's what this is. It's a recertification. We believe we have the evidence to prove this case. All of these media reports do not undermine that good faith certification that we made when we filed the case. And I think this is where it's helpful to look at. I have this here. We cited a case, Kansas, State v. Wright, 583 Pacific 3rd, 174, where the prosecutor in that case in jury selection, so this is a much more direct, this is right to the jury pool who's going to try the case, right? In that case, the prosecutor says to them, see if I can find this quote. Oh, I've got the wrong pleading up. Okay, I had it on the page. Thank you for asking that question. I meant to cover this. In State v. Wright, 583 Pacific 3rd, 174 on 194, this is a Kansas Supreme Court case from 2026. The county attorney, speaking to the veneer, the jury panel for jury selection, says this. So as the county attorney, my job is to prosecute cases that are brought to my office that I feel we can prove beyond a reasonable doubt. Then he continued, that is the burden that the state willingly accepts when it filed charges and brings cases forward. So the state understands this burden and intends to prove that through the course of evidence this week. And the Supreme Court ruled as follows. Rather than an improper personal opinion on Wright's guilt, the prosecutor's comment here simply explained the prosecutor's role in the proceedings and reiterated the state's burden of proving guilt beyond a reasonable doubt. A prosecutor in a criminal case cannot ethically prosecute a charge that the prosecutor knows is unsupported by the evidence. That's what was happening here, Your Honor, is saying Mr. Ballard testified. This answer was in response to the question, do you still have a case, right? Does your case fall apart here with the evidence? And his opinion was not, I believe he's guilty. It was an opinion directly tied to the evidence. We believe we have the evidence to prove this case. And it's nothing more than a certification that all attorneys make when they make filings and that the county attorney made when filing the information in this case. It's much less prejudicial than anything the attorney said in State v. Wright because it's directed to the media rather than the jury veneer. And it's not prejudicial anyway. I don't think anyone would be surprised to learn that the prosecutors in this case believe they're going to be able to prove it. In fact, I think if the public thought we were prosecuting cases we did not believe we could prove, that would be, frankly, shocking because it wouldn't make any sense. I think everybody knows that we believe we can prove this case, and we intend to do so through the evidence, not based on personal opinions that are endowed on us through our authority as prosecutors, which seems to be what Levitt claimed in that case.
Thank you, Mr. McBride. All right.
Can I beg the court's indulgence for 90 seconds?
I will give you 90 seconds, Mr. Novak.
Thank you, Your Honor. I think we all want the court to be clear on the law with respect to the third element and intentionality. And Mr. McBride is not correct when he says that all of the cases that we cite for the proposition that violation of an order enjoining conduct requires proof of intent predate Von Hake. That is not true. And so what I want to just remind the court is that in 2019, the United States Supreme Court said, and this is at the bottom of page 10 of our reply, the United States Supreme Court said, quote, "We have explained before that a party's subjective belief that she was complying with an order ordinarily will not insulate her from civil contempt if that belief was objectively unreasonable." That's Taggart v. Lorenzen, a 2019 Supreme Court case. And in the same year that Von Hake was published, the United States District Court for the District of Utah said that civil contempt for violation of a court order need not be willful. And now I'm going to quote from the District of Utah opinion. In order for a party to be cited for civil contempt, a court must find that the party violated a specific and definite court order, and that the party had knowledge of the order sufficient to put him on notice of the prescribed conduct. Nevertheless, the disobedience in a civil contempt need not be willful, because the purpose of civil contempt sanctions is remedial. That's In re Skinner, a 1988 published decision in Bankruptcy Reports, District of Utah.
Thank you, Mr. Novak.
And I have nothing further unless the court wanted to inquire of me concerning anything Mr. McBride said.
No, thank you.
Thank you.
All right, we're switching gears, going to the motion in limine to exclude hearsay statements as mentioned in the briefing. Again, I will note that the court has examined those briefings in detail, and so the court wishes for limited argument as the briefing provides a lot of guidance from both sides on the parties' positions. And so if the parties would like to take up to 15 minutes to argue that, you certainly can, and then we'll go to the final issue that Mr. Novak brought up in the beginning. And as this is defense's motion, we'll turn to defense. Mr. Burt.
Morning, Your Honor.
Good morning. Well, afternoon now.
Afternoon, I guess. Judge, as the court knows, and as you've just noted, there's been extensive briefing here. I'm not going to get into all the technical arguments, and there are many here. But the briefing outlines 6 different bases for the court to find here that the use of hearsay evidence in this particular preliminary hearing in this death penalty case is unconstitutional under the federal constitution. The state constitution has separate rules, as we outline in the brief, and I know the court's familiar with those. But the constitutional issues raised under the federal constitution are unique. For the most part, they have not been addressed by any Utah court, with one exception, and that's the confrontation clause objection that is addressed in Timmerman. But as to our other arguments, procedural due process, equal protection, the Sixth Amendment right to counsel, those issues have not been addressed. And there's, of course, one issue, separation of powers, that's a state law issue. That has also not been addressed by any Utah court. But I wanted to take just a few minutes for the court, if I could, to outline why this motion is important in this particular case. I don't think that's really outlined in the motion, but I think it's important for the court to consider. And I know the court has not reviewed the exhibits that have been submitted to the defense from the prosecution in terms of what they're going to present at the preliminary hearing. But I'll represent to the court that for the most part, the state, and I'm sure they'll correct me if I'm wrong on this, intends to rely almost exclusively on hearsay evidence at this preliminary hearing to make out the elements of the charges and allegations, and especially the death penalty eligible allegations against Mr. Robinson. And probably most problematic from our standpoint is that the central witness who's going to be presented against Mr. Robinson is a witness who the prosecution and the federal government have given promises of immunity to. And in lieu of putting that witness on the stand and subjecting him to cross-examination, they met with this witness outside the presence of the defense, asks a series of leading questions that the witness was asked to agree to, videotaped it, and the state proposes to introduce that into evidence. In addition, a prominent feature of the evidence at the prelim will be a number of forensic reports by federal and possibly some state law enforcement forensic examiners. And those reports, for the most part, are simply conclusory opinions about certain findings that were made. There is no indication on the face of the report as to the methodology that was used or the reliability of those methods. The reports are simply going to present the court with conclusions. And then the state is going to rely on Section 1102 of the Rules of Evidence to urge this court that those statements by law are reliable evidence. And that's the gist of the problem here, because 1102, in combination with Article 1, Section 12, essentially removes what was supposed to be this court's function at the preliminary hearing, which is to assess the reliability and the credibility of the evidence. And the intent of Article 1, Section 12, if the court goes back into the legislative history, was specifically to remove the court's discretion to decide whether certain evidence was reliable. And that's where the separation of power issue comes into play. Now, that, we say, violates the federal Constitution in a number of respects, and also the state separation of powers provision. But I wanted to point out to the court that the state's position on this issue is really contrary to the position they've taken on almost every other procedural issue that has been raised in this case. And the prime example is the one just presented to the court in connection with the OSC. One of the things that Mr. McBride said was, we have a duty to make sure the truth gets out there. And similarly, the defense has a duty to make sure the truth gets out there. And how they do that in this system, traditionally and historically, has been through the use of cross-examination, confronting adverse witnesses. Another example of the inconsistency that's being urged upon the court in the state's opposition to this motion. The court will recall the state's position on our motion to exclude cameras from the courtroom. And Mr. Grunander began his argument to the court with this statement: Your Honor, mischief lurks in the dark or in secret, or that's at least how many people view the workings of government, even the courts. And while this is primarily the media's fight here, we do not represent the media. We strongly support open and transparent proceedings in this case so that the public will trust the process here. There are conspiracy theories that abound. There are questions being raised. And the best antidote for falsehood is the truth, is accuracy, is the actual real proceedings. And that's at page 214 of the hearing on April 14th. And similarly here, Your Honor, the defense's right to cross-examine and confront adverse witnesses, immunized witnesses in this case. We're going to provide the bulk of the evidence against Mr. Robinson. The purpose of our doing so is to get at the truth, to lead to transparency. And one of the articles that the state has cited to the court as indicative of an analysis that's relevant to this issue is an article by a former district attorney who, this is the Bowden article that the state cites. And one of the things that Mr. Bowden, former prosecutor, says in his article that the state cites is he's addressing the issue of why it's important to have adversary proceedings at pretrial proceedings such as preliminary hearings. And he says, this is at page 1148 of his article, a system without adjudication lacks transparency. The public normally has no way of learning why prosecutors make the offers they do or why certain cases reach certain outcomes. The opacity prevents the public from understanding how criminal courts function. It frustrates journalists and scholars who wish to study criminal courts, and it distorts democratic feedback as voters are left with little idea of how these institutions work. And the court, in its rulings on public access, and even this morning, you have also emphasized transparency as a goal of the criminal justice system. So this motion asks the court, how can we further transparency by relying exclusively, or almost exclusively in this case, on hearsay evidence that implicates Mr. Robinson in a death penalty case? And we say to the court that if the court looks carefully at the cases we've cited on the federal constitutionality of this practice, the court should determine that it's simply unfair to proceed on the basis of hearsay in a case where Mr. Robinson's life is at stake. The federal constitution requires that people who are facing parole revocations have the right to confront and cross-examine witnesses. The U.S. Supreme Court has determined that people facing probation violations have a right to confront and cross-examine witnesses. The state Supreme Court has determined that people at suppression hearings have the right to confront and cross-examine witnesses. The state Supreme Court has determined that people who face sentencing have a right to confront and cross-examine witnesses. And we say that due process, equal protection, and the other provisions we cite all point in the same direction, which is that the court should not allow the use of hearsay to make the determination in this case that Mr. Robinson should or should not be bound over for trial. And I'll be glad to answer any questions the court may have. I know the briefing's fairly extensive, so if the court does have questions, I'm prepared to address them.
I do. I have one question. I'll be asking both sides this question.
Sure.
And the court previously indicated, and you noted it, that it wasn't reviewing the exhibits ahead of the preliminary hearing in order to go in with an open mind and weigh it accordingly. But is it your request that the court review the proposed state's exhibits that relate to this motion prior to the preliminary hearing?
Your Honor, I think it would be helpful to the court to do that because I think the court would then have a better context of just how central hearsay is going to play in this case. And also, especially in regard to the crucial witness, the immunized witness, how the state structured that hearsay. And I think if the court did that, it would clearly see the importance of cross-examination and confrontation. So I would have no objection to, and I would urge the court to do that.
And do you have those exhibit numbers? And if you need time to confer with your team as I go to the other side, I don't expect you to just come off with those numbers off the top of your head.
Sure. I know the court, the state provided those to the court. I think there was some email traffic about how the court then gave them back to the clerk, but I think they're still in the clerk's possession. The state will correct me if I'm wrong on that.
Right.
But they're the state's exhibits, so.
No, you're right. I know, but I'm wondering if there's specific ones that you want to identify that relate directly to your motion that you wish the court to review.
Yes, Your Honor, if I could have a minute, I'll identify what those exhibit numbers are.
All right, so I'll turn to the state. And
Great.
Again, I'm not trying to put you on the spot there.
Understood.
All right, Mr. Ballard.
Thank you, Your Honor. The Utah Supreme Court has already rejected the defendant's argument in State v. Timmerman. This court can't overrule the Supreme Court. And I think it's fundamental, or it's important to think about the fundamental reason why the court held in Timmerman that the Sixth Amendment right to confrontation does not apply at preliminary hearings. And it's because of the very, very low burden and low standard that the state has to meet at a preliminary hearing. All we have to show is probable cause. The magistrate at a preliminary hearing isn't making any factual findings. The issue is just whether there is a reasonable probability of that an offense was committed and that the defendant committed it. And in making that decision, as Your Honor well knows, you have to draw all of the inferences in favor of the state. You can't weigh conflicting evidence. You can make only very, very limited credibility determinations. So even if the defense could impeach a witness to some degree through cross-examination, like the fact that this witness has been granted immunity, it doesn't matter at the preliminary hearing because the magistrate's duty-bound to ignore those blemishes and draw all reasonable inferences in favor of the state. So even if the state's only witness to a robbery was a convicted forger who wasn't wearing his glasses when he saw the robbery and who had a grudge against the defendant, even if the defense could bring all of that out on cross-examination, it's irrelevant to the probable cause finding because it's such a low burden. That's an extreme example. I don't think the state would ever bring charges in a case like that, but we do have an example that is similar in scope to that, and that's State versus Drozbecki. That I think is how you pronounce the name, Droesbeke. That's 2010 Utah App 275. In that case, you had a child victim of sexual abuse who reported the sexual abuse to law enforcement, reported it during a CJC interview, but then took the stand at the preliminary hearing and recanted those allegations. That there was still sufficient evidence under that situation to bind the defendant over, even though the witness recanted those allegations, because there was a reasonable explanation as to why the witness might have been telling the truth when she reported to the police and during the CJC interview, and why she might have recanted at the preliminary hearing. So that's the standard that the court is applying. And so defense talks about we have to have reliable evidence. And the state absolutely agrees that we have to have reliable evidence, but reliability, the degree of reliability depends upon the circumstances of the proceeding. So is hearsay sufficiently reliable for a conviction beyond a reasonable doubt at trial? Certainly not. But is hearsay reliable enough to be able to make this low probable cause finding? Yes, it is. And that's why Timmerman held that the Sixth Amendment right to confrontation does not apply at preliminary hearings. And that's why nearly every other state court that has examined this issue has found that the Sixth Amendment right to confrontation does not apply. Timmerman collected those cases as of 2009. You've also got the Ninth Circuit in Peterson versus California, and we've included all of these cases in our brief. In fact, if this court granted the defendant's motion, it would be going where no other court has gone before. This court would be the first court to find that the Sixth Amendment right to confrontation applies at a preliminary hearing. Because Timmerman is clear that the Sixth Amendment right to confrontation doesn't apply at a preliminary hearing, defendants trying to rely on other federal constitutional provisions. But defendants' attempt to do that violates the rules of constitutional construction, legal interpretation, because it would create contradictory constitutional provisions. What defendant is trying to say is even though the Sixth Amendment right to confrontation, which we know would provide the right to cross-examination and therefore prevent the state from relying on hearsay, even though that right doesn't apply at the preliminary hearing, there is some other constitutional right that could somehow indirectly provide that right. But then we would have two conflicting constitutional provisions. And that's not how we read the Constitution. That's not how we read statutes. We read them to be in harmony with each other, different provisions to be in harmony with each other, and to not render a different provision superfluous. If you could provide the right to confrontation through the Sixth Amendment right to counsel or 14th Amendment right to due process, then what work is the Sixth Amendment right to confrontation doing? It just doesn't make sense to do that. So that's exactly why the Ninth Circuit in Peterson versus California said it's illogical to conclude that the substitute for a grand jury indictment, which is the state preliminary hearing procedure, must contain greater protections than the grand jury provides for itself in the federal system. So if the federal system, the equivalent to the state preliminary hearing is a grand jury proceeding. The grand jury proceeding allows the federal system to determine probable cause to require a defendant to stand trial. The defendant doesn't have a right to be present in those proceedings, doesn't have a right to representation, doesn't have a right to cross-examination, or even to present exculpatory evidence. If that type of a procedure is constitutional, then Utah's preliminary hearing procedure is certainly constitutional. I could go through each of the different constitutional provisions that defendant has relied on. I'll do that very briefly, just summarize the reasons why we don't believe those apply. The Sixth Amendment, even assuming the defendant could rely on some other provision, which we don't believe he can, but the Sixth Amendment right to counsel, it doesn't create additional rights. What it does is it evaluates counsel's performance under the circumstances as they existed at the time. Now, defendant brought up the fact that there is a right to confront witnesses at suppression hearings and at sentencing hearings and at parole revocation hearings. That's a procedural right to cross-examination. It's not a Sixth Amendment right to confrontation. We know from Crawford versus Washington, the Sixth Amendment right means that the state cannot rely on hearsay evidence that a defendant has not had a prior opportunity to cross-examine. And so it's the Sixth Amendment right that prevents the state from relying on hearsay. That's completely different from saying the defendant has the right to be able to cross-examine any witnesses that the state calls. And in fact, at a preliminary hearing, the defendant will have the right to cross-examine. I think we're planning on calling 4 witnesses. Defendant will have a right to cross-examine those witnesses. But a procedural right to cross-examination doesn't mean that the Sixth Amendment right, as interpreted in Crawford, applies and precludes the reliance on hearsay. With respect to due process and the 14th Amendment, again, you have to look at what process is due under the circumstances. And here, again, we've got a very low standard. And the state's process here gives the defendant far more protections than the federal grand jury proceeding does. Both of them determine probable cause as to whether the defendant can go to trial. And so due process doesn't supply some sort of right to confrontation that the Sixth Amendment right doesn't supply. The equal protection argument is interesting because defendant has not shown that he's similarly situated. Well, let me back up. What defendant relies on is Morrissey versus Brewer, which is the case that says defendants have a right to confront and cross-examine witnesses at a parole revocation hearing. But that's a defendant who has been convicted at trial and who is facing reimposition of a criminal sentence to serve out the remainder of his sentence. Defendant here isn't similarly situated to that type of a defendant. So he can't make an equal protection challenge based on that situation. And again, Morrissey versus Brewer does not say that the Sixth Amendment right to confrontation applies. It merely says as a matter of due process, if the state is calling the witness, the defendant has the right to cross-examine them at the proceeding, just like defendant does at this preliminary hearing. As far as the Eighth Amendment goes, the state doesn't have any qualms with the idea that the Eighth Amendment, if we get to the point of whether or not the death penalty is an appropriate penalty here, certainly the Eighth Amendment heightened protections apply there. But we're not at that point, and defendant hasn't cited any case that would extend those Eighth Amendment protections beyond the decision to impose the death penalty or They do cite Beck versus Alabama, which talks about instructing the jury at the guilt phase. We're not at that point. You can't use the Eighth Amendment and say, well, because this is a death case, there's super due process or there's additional rules that apply above and beyond the procedural and evidentiary rules that apply at every other stage of this proceeding. And then finally, as to separation of powers, I don't see anywhere in the federal Constitution that dictates any particular separation of powers principles to the states. And so it's completely up to the state of Utah to determine how it wants to divide the powers between its various branches of government. And the constitutional provision that's at issue here clearly says that that reliable hearsay can be defined as by statute or by rule. So the Constitution itself is giving the legislature and the courts the ability to define what constitutes reliable hearsay. As far as Your Honor's question about what you would like, what the state would like you to review as far as the exhibits go, we just renew our request that the court review all of the exhibits in preparation for the preliminary hearing.
Thank you, Mr. Ballard.
Any other questions?
No, thank you.
Okay.
Mr. Burt.
Court, I've circled the exhibits we're asking the court to review. They are exhibits 11, 16, 30, 31, 32, 33, and 34. I have a copy for the court with those highlighted if the court
Thank you,
would like
Mr.
it.
Burt. Yes, and if
May
you'd
I
like to
approach?
approach, you may. I appreciate it. All right. Thank you to both parties.
And Judge, could I just briefly respond
Oh,
to
of
the
course.
arguments that were made by the state? Just quickly to run through them. The state emphasizes there's a low burden at the prelim. Granted, it's a low burden, but as the State versus Virgin, VIRGIN case said, low burden does not mean no burden. And the U.S. Supreme Court in Coleman versus Alabama recognized that the burden of proof at the prelim is very low. They nevertheless held that the defendant has a Sixth Amendment right to the effective assistance of counsel. So the fact that it's a low burden does not govern whether procedural rights should be applied. And the Coleman case holds exactly that. The state says that the degree of reliability depends on the nature of the proceedings. That's true. But this is a case where the state of Utah has provided procedural rights at the preliminary hearing, unlike grand jury proceedings. There are rights granted by statute to counsel. There's constitutional right to counsel. There is a right by statute to call defense witnesses, to subpoena witnesses. So the court has to take those procedural indicia into account in determining what other rights might be applicable. And both the U.S. Supreme Court and the Utah Supreme Court has said that the preliminary hearing is a critical stage of the proceedings. The state says that, citing this Ninth Circuit brief opinion, the Peterson case, that it's illogical that the preliminary hearing must have greater protection than grand jury proceedings. It might be illogical, but the reality is that defendants are accorded greater rights in preliminary hearings than in grand jury proceedings. There is no right to counsel at grand jury proceedings. There is no right to subpoena defense witnesses at a grand jury proceeding. And yet in Utah, as elsewhere, defendants do enjoy those rights to certain protections. And once having defined that it's an adversary critical proceeding, the state has an obligation to provide the tools necessary to make that confrontation meaningful. State emphasizes that the defense has a right to call witnesses. Theoretically true, but irrelevant in this case because, as the court will see from reviewing the exhibits, How the state proposes to make its case in this case is exclusively through the use of hearsay. So calling a record custodian or a police officer who has no knowledge about the essential elements of the offense, the defense could cross-examine that person on some chain of custody issues, but it's got nothing to do with the critical issues before the court, which are the essential elements shown by probable cause. And in this case, those elements are going to be satisfied by hearsay alone. The defense says that, or the state says that there's no equal protection problem here because we're not similarly situated to probation or parole violators. In all three of those cases, the interest at stake is whether the defendant should be confined for prolonged periods of time pending the outcome of his hearing. So a parole revocation hearing, especially the preliminary parole revocation hearing, is very, and in fact, it's indistinguishable from a preliminary hearing. The goal is the same, to determine whether there's cause to hold the person, deprive that person of liberty pending further proceedings. So there is an equal protection violation here. The state says that the court can only look to the Sixth Amendment. As I understand the argument, the court cannot look to procedural due process as guaranteed by the 14th Amendment. It cannot look to equal protection. It cannot look to the 8th Amendment. It cannot look to any other doctrines beside the Sixth Amendment to determine confrontation. And we've pointed to the court a long line of cases in both the U.S. Supreme Court and the Utah Supreme Court, which refute that contention. It's clear the court has an obligation to look at whatever constitutional provisions are implicated by the procedure in question. And the Utah Supreme Court, when it was looking at the subpoena powers case, looked at whether the act violated confrontation rights, equal protection, separation of powers. No one ever suggested that the court had no power to look at various constitutional theories. That theory is not supported by the case law. And then lastly, the state says that we've cited no cases to the court saying that the 8th Amendment applies to the preliminary hearing procedure of this case. And that's simply not true. Gregg versus Georgia said that every procedural protection must be observed in a capital case, not at a capital trial, in a capital case. And as charged right now, this is a capital case. And we've also cited to the court the Ford case, Ford versus Wainwright, also along the same lines, saying that in capital proceedings, there's a heightened need for reliability. And then lastly, in our reply, we cited a whole string of state court cases which hold that at the preliminary hearing, not the trial, the preliminary hearing, the court has an obligation to employ a heightened standard of reliability. Thank you.
Thank you. All right, thank you to the parties. We're turning to the last item, and just cutting to the chase, does the state oppose defendant's request on docket 593?
Can I have just a moment?
And there is also the scheduling of the responses to an EMC request, which we discussed.
Okay, well,
We need
thank you
to
for
deal with that as
reminding me
well.
of that. Thank you, Mr. Novak.
Your Honor.
If you would like to approach the lectern, Mr. McBride.
Your Honor, so this is basically a motion to begin the process of compelling and of getting a subpoena for an out-of-state witness.
Yes.
Here's the issue is, we know that from the pleading that the out-of-state witness's attorney has declined to accept service for their client. And this witness has appeared by 11:02. We believe that that's appropriate and satisfies probable cause. The rule requires defense counsel to certify that this witness is necessary and material to the probable cause determination. Under State v. Lopez, we don't believe it is. We got this at 8:03 last night. I looked at it for the first time just moments ago. What I'd really like to do is have a couple of days to respond to this. I know time is of the essence, but that's where we're at. So I really don't want to respond right now. If I did, I'd probably submit on what I've said right now.
I see. Thank you. To defense, is there any additional briefing needed in addition to what you've submitted on docket 593? And so I'm just seeing if there is, trying to create an expedited.
Only to respond expeditiously to whatever the state files. So for example, and again, we're both going off the fly, I'm now responding to Mr. McBride's statement. This is not a Lopez situation. The witness is not the victim in this case, as Your Honor knows. So it's not a Lopez situation. It's a question of whether the witness is a material witness. So I think to squarely answer the court's question, we need a very short period of time after the state responds, and if the witness's counsel wants to respond, to file, I guess, what we would call a reply. But we are moving we can move as quickly as the court requires.
Thank you. To the state, how much time, and again, I realize that this appeared on the horizon.
We can have till Tuesday close of business.
All right, so we're looking at Tuesday, the 16th of June.
Yes.
All right, close of business. Mr. Novak, with that information.
I think Thursday, the 18th.
All right. I close of business as well.
And actually, in some ways, this may or may not sync. Anyway, go ahead, I'm sorry.
Well, and I know where you're going. Does that sync pretty closely with the last remaining issue, briefing on the potential? Well, the problem with that is until it's filed, the request for an EMC, that starts the time. My lawyer math doesn't get me to how close we are to the prelim off the fly, but that's the trigger point.
I was an economist before I was a lawyer, so
All right,
my
that'll
math
allow
might
you.
help. So you just want to hold that there for a second and move on to the other one and then see if they're in sync, or what did you want to?
Well, and I'm fine. It sounds like we have a good understanding for the briefing on that particular docket 593. So that's been resolved. Turning to the last issue is in regards to the EMC. When would the 14 days?
So right now, the court's order from May says that media requests need to be filed 14 days before the proceeding. 14 days before the proceeding, which is on July 6th, is June 22nd.
So
Which
a
would
week
not-
from Monday.
Pardon?
A week from this coming Monday.
So this is what I was going to propose, and we did meet and confer about this. And my understanding of the state's position is they don't want the court to change its order. Okay, so I understand that's their position, but here's our proposal. We propose that for purposes of the preliminary hearing of July 6th, if it proceeds on that date, that the court adopt the following schedule. Any request for electronic media coverage should be filed next Wednesday, June 17th. And we will take it upon ourselves, meaning Mr. Robinson's defense counsel, to personally notify counsel who've entered their appearances on behalf of the media entities of any new deadline that the court sets today. So we will notify them so that the court doesn't have to rush into publishing an amended order unless the court wants to do so. But we can notify them, copy the state, copy the court staff. It's a form, as I understand it. This is the event, this is who's going to be behind the cameras. It's submitted. Okay, it's not a complicated document. So this is my suggestion, is that we will notify the media representatives today that any request for EMC needs to be filed with the court by the 17th, which is Wednesday. Today's Friday. We have an issue which is a small delay between when it's filed and when it's docketed. And so what I'm going to suggest is that 2 court days after it's docketed, we will file, anybody who's opposing it will file a response. And then 2 more court days for anybody who wants to respond to that, and 2 more court days for a reply. The court's already set page limits, which are very modest. I think it's 4 pages, and 3 pages. That's fine. The court has said there won't be any oral argument. That's fine. But if my schedule plays out correctly, and we got a docketed EMC request on the 17th, and we filed our response on the 19th, and the state filed any response to our papers on Monday, the 22nd, and then we filed a reply on the 24th, it would be fully briefed by the 24th, which gives us 6 + 6, 12 days before the prelim.
All right. Thank you, Mr. Novak. Does the state wish to be heard on this issue?
Yes, Your Honor, thank you. I think we're not discounting the importance of and the significance of the media issues in this case. But I think it's significant, as Your Honors already noted earlier this morning, that you granted a very generous opportunity to deal with these electronic media requests, that it's far more generous than what the rule requires. It appears to me that what the defense wants is an opportunity to get a ruling from this court on electronic media requests, so that then if it's a ruling that they don't agree with, that then they can seek yet another interlocutory appeal and perhaps file a motion to stay this case. And if you look at the procedure that the rule has already established, the controlling rule 4-401, the rule does not contemplate appellate review of every electronic media coverage order. And that's clear from the fact that the rule only allows 1 day notice for a request for electronic media coverage. And in fact, it says that the court on good cause can grant a request for electronic media coverage. It can shorten the 1 day time. I think it could be, as the hearing commences, if there was good cause. So as the court has already established its schedule, it allows 14 days before the hearing for the request. Under that current schedule, the court could have a ruling on the request by July 2nd, which would be before the hearing. So we don't believe that this procedure, which presumes that electronic media coverage, those requests will be granted, that it needs to be set up so that there can be the potential for appellate review of every one of those orders. Thank you.
Thank you. All right. Thank you to the parties. I appreciate you conferring with each other and trying to find a solution. I'm going to respectfully decline to adopt what Mr. Novak presented, and here's why. There's nothing that precludes the media from filing today. That request in being ahead of the deadline. And again, that's outside of my purview. It's their choice if they choose to file or if they choose to file one at all. And so the court will rely upon the previously set schedule. Again, if the media files early, that doesn't preclude the parties from filing as soon as they can or they wish to, and the court still having sufficient time to do its duties. And so that's the ruling of the court as it relates to a different schedule as it relates to media requests for coverage, EMC, of the preliminary hearing on July 6th. It goes to the very last issue, which is the court is taking these two issues argued today under advisement, and as this court typically does, I always like to review everything, and I appreciate the quality of the arguments, the quality of the briefing, and what is clear to me, the hard work of both defense and prosecution and the seriousness applied to these important issues. If you wouldn't mind taking a look at your calendars, the court has an opening on June 22nd at 9:30 a.m. to issue rulings on both of these matters. And as is traditionally has happened, it's done on WebEx, but of course I'll hear from the parties on their preference as well as the attendance of Mr. Robinson at that hearing.
That date works for the court, and we would prefer WebEx for the state. Sorry.
It's okay. 9:30 in the morning.
That's fine with Mr. Robinson's counsel, and we will ask that Mr. Robinson appear by WebEx audio only from the jail as usual.
All right. Thank you to the parties. Anything further? Any party needs the benefit of the record before we go into adjournment? All right. Thank you all, and court is now adjourned.